Good morning. I'm calling to order the Tuesday, July 29th, 2025 meeting of the State Election Board. My name is John Favre. I'm the chairman of the board. We have a quorum present today. Missing one member who I assume will be here shortly. You'll note that we changed up the agenda a little bit this time so that we've tried to accommodate those people that are traveling from far distances, and they will hear their cases on the first day, and then those local Atlanta counties will hear their cases on day 2, and hopefully it will prevent people from having to sit through 2 full days of hearings and cases. We also changed up a little bit the public comment at the request of members of this board will happen at the end of every day. We just have 3 individuals that have signed for public comment so far, but that'll happen at the end of each day instead of the beginning. So let's appreciate all y'all being here today, and hopefully we'll get through our business pretty quickly and get you home quickly. So if we could start with Member Gazal, would you lead us in Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Member Gazal. What do you want to let Rick? We're going to do that, Rick. I'm sorry, Rick. That our new executive director Mills will lead us in invocation.
Let's bow for a word of prayer. Father, I want to say thank you for the gift of today. While we slept last night, you kept the blood running through our veins. You kept our lungs working. And God, we slept. You woke us up this morning. God, you gave us the sun, you gave us the sky, and you gave us this responsibility. And so I pray for each member of this state election board, God, that you would grant them wisdom and discernment, and Lord, that we would lean upon your wisdom, because we lack wisdom, and you tell us if we lack it to ask you for it. So we ask you for that. And God, I ask you to forgive us when we've sinned against you. Forgive us when we've sinned against our brothers and our sisters. And God, we ask your blessings on this meeting, and that what we say and what we do will bring honor to you. And it's in Jesus' name I pray. Amen.
The next item on the agenda is approval of the board meeting minutes from May 13th, 2025 and May 14th, 2025. A copy of those minutes are in your file, should be in your file. And if you we'll take a minute to review those. Are there any questions or from the members of the board on the minutes? If not, Chair will entertain a motion to approve the minutes from the May 13th and May 14th, 2025. We have a motion. Is there a second? We have a motion and a second to approve the minutes from May 13th, 2025. Any discussion? Hearing no discussion, all those in favor of approving the minutes signify by saying aye. Any opposition? Hearing no opposition, so moved. The next item on the agenda is the Attorney General's report. We have quite a few cases to go through. Beth Young from the AG's office is here to go through her cases with us. Hang on a second. Welcome. Please proceed.
Okay. We've got just a few cases. I'm going to try to get through them as quickly as I can so that since I know that y'all have a lot on your agenda this morning. Our first 4 cases are consent order cases. Each of these are cases that involve respondents that have worked with our office and agreed to payment of a fine in an amount that we feel like is sufficient to forego a full Administrative Procedures Act hearing in front of the Office of State Administrative Hearings. The first case is case number 2019-038. This comes from the city of Arlington general municipal election in November 2019. The respondent is Carolyn Mosley Oliver. She was a candidate for Arlington City Council at the time. She was driving an elderly voter to the precinct and came up in her car that did have election signage on it. And in the process of trying to bring this lady to the polls, ended up violating two provisions of the law, one being parking her car with campaign signage within 150 feet of the polls, and also being at the polling place as a candidate in general. There's a provision in the statutes that say that if you're a candidate, you're only supposed to be at the polls to vote. When she was told not to be there, she tried to get the election workers to assist the person from the car. Apparently there were mobility issues. Turned out the voter was actually not even registered to vote. So the voter ended up going home with her. She said that the violation was not intentional, but she does acknowledge the violation and has agreed to payment of a $250 fine. We feel that's appropriate under these circumstances and would recommend that the board accept the negotiated consent order.
Are there any questions from the board on this case number 2019038? The chair will entertain a motion from the board.
We accept the recommendation of the Attorney General.
There's a motion to accept the recommendation of Attorney General. Is there a second?
Second.
There's a motion and a second from member King, I believe was first. Any discussion? Hearing no discussion, all those in favor of accepting the Attorney General's recommendation signify by saying aye. Any opposition? Hearing no opposition, so moved. The next item on the, or next case on the agenda is SCB 2020-001.
Okay, this case involves a respondent who was an individual voter from Early County. She acknowledged that she signed her husband's name on an absentee ballot on the grounds that she said that he was experiencing medical issues at the time. She acknowledges that she erred in doing that and should not have done that, and has agreed to payment of $100 fine. And we think that that's appropriate given the circumstances and recommend that the board accept the consent order.
So proposed resolution is $100 fine. Any questions from the board? Any no questions? Chair will entertain a motion.
A motion that we accept the
Attorney General's recommendation.
as it.
We have a motion to accept the Attorney General's recommendation. Is there a second?
Second.
We have a motion and a second. Any discussion? Hearing no discussion, all those in favor signify by saying aye. Any opposition? So moved. The Attorney General's accepted 3-0. Next item on the agenda is SCB 2020-147.
Okay. The respondent in this case is a poll worker from Spalding County that inadvertently allowed a voter to vote twice, once by absentee and once in person. The voter showed up at the polls asking if their vote had been counted, and when the respondent looked at ElectionNet, she advised that voter that that vote had not been received and that they could go ahead and vote in person. They did not realize that the absentee ballot had already been accepted, and so that voter did end up voting twice. The respondent acknowledges that this was an error on her part and has agreed to pay a $250 fine. We recommend that they accept that consent order.
So the recommendation is a consent order implementing respondent cease and desist, public reprimand, and $250 civil penalty. Any questions from the board? Dr. Johnson.
Ms. Young, did the poll worker receive a letter of reprimand
Not that I'm aware of. Usually, when a case is referred to our office, that's in lieu of a letter of instruction or reprimand. But there is a provision for reprimand and cease and desist included within the consent order. That is true for all the consent orders that we have been, presenting to y'all.
Thank you.
Any further questions? Chair will entertain a motion.
Make a motion that we accept the recommendation of the agent's office as is.
We have a motion to accept the recommendation. Is there a second? Second. We have a motion and a second. Any discussion? Hearing no discussion, all those in favor of accepting the recommendation for consent order, implementing a cease and desist, a public reprimand, $250 civil penalty. All those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved 4-0. Next item on the agenda is SCB 2020-201.
This is a consent order that the Spalding County Board of Elections has agreed for a $500 fine in a case that involves kind of a number of irregularities. It began with some sort of error in their poll pads, in which a number of voters at this particular election showed up at the polls and were being told that it was showing in the poll pad as they had already voted. There's no clear indication in the file in terms of why that error ended up appearing. The poll workers, for the most part, did the correct thing and had those voters vote by provisional ballot. And with all but one exception, those ballots ended up being validated and counted. One of the voters, however, actually two of the voters, a husband and wife, had the form filled out to request a provisional ballot, but the signature lines were not executed. It looks like the poll workers forgot to have them sign it. So they got a call from the election superintendent to come back in and sign it, which they did. But in the interim, someone signed the husband's name. The husband immediately recognized that was not his signature. There's not a very clear indication in the file in terms of who exactly might have executed that signature on his behalf. Bryan County, most of these people, of course, no longer work for Bryan County, but they have agreed that, due to these errors and irregularities, that they will pay a $500 fine, which we think is appropriate under these circumstances, along with a cease and desist and reprimand. And we recommend that the board accept.
And the proposed resolution is consent order against Craven County Board of Elections and Registration incorporating a cease and desist, public reprimand, training, and $500 civil penalty. Any questions from the board?
Just one quick question. This, just to clarify for the audience and for the record, this includes training in addition to the cease and desist and the reprimand. Correct?
Yes, and I believe that the particular system that that caused this initial error with poll pads in the first place is no longer in use. So I don't think that there's a concern there will be a repeat of the initial problem that led to the provisional ballots having to be issued in the first place.
Very good. Thank you. No further questions.
The chair would entertain a motion at this time.
Mr. Chair, I move that we accept the recommendation of the Attorney General.
We have a motion to accept the recommendation. Is there a second?
Second.
We have a motion and a second from Member Jeffries. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. Next section is for final orders. The first one is SCB 2019-014.
Right. For the next two cases are final order cases in which we are going to be recommending that the board enter an order that provides for a cease and desist and a reprimand without payment of a penalty. 2019-014, the respondent was a facility manager at a care home. And she thought it would be a good idea to incentivize the residents to vote by letting their proof of vote be entered into a raffle for various prizes. She did not realize that that is a violation of the law because one is not to compensate people for voting, regardless of who you vote for. When she was told that it was an error, she was very apologetic. She posted signage throughout her facility, explaining that that had been an error. The raffle was never conducted. No compensation was ever received. And in this circumstance, given that this appears to be an inadvertent violation, we think it'd be appropriate to close this matter without seeking a penalty against this individual. So we recommend resolution with a final order for cease and desist and reprimand.
So it said the final order is just a cease and desist letter.
Yes.
Okay.
Mhm.
Any questions from the board? Chair will entertain a motion.
Make a motion that we accept the recommendation of the AG's office.
We have a motion to accept the recommendations. Is there a second?
Second.
We have a motion and a second from member Jeffries. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved, accepted 4-0. Next item on the agenda is SCB 2020-218. It's a final order.
The respondent in this case is Lynn Vickers. She was the Pike County Board of Elections and Registration Supervisor. And in the January 5th, 2021 runoff election, it was brought to her attention that she was late in sending an absentee ballot to a Uocava service member. She was 2 days behind the due date for sending those ballots. The service member did receive her ballot in time to cast her vote and have her vote counted in the election. She was new to the position at the time, didn't realize that she had the ability to run an ENET report that would have highlighted this lapse for her. But at this standpoint, she no longer works for Pike County, and we do not think that a hearing before the Office of State Administrative Hearings to impose a penalty against her in her individual capacity for what is clearly an unintentional administrative error would be appropriate. So we're recommending a final order with a cease and desist and reprimand.
So the proposed resolution is a final order, cease and desist, and a reprimand. Any questions from the board? Chair will entertain a motion.
Mr. Chair, I move that we accept the recommendation of the Attorney General.
We have a motion to accept the recommendations. Is there a second?
Second.
We have a second from member King. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. It's accepted 4-0. Next item on the agenda is orders of dismissal. And the first case is SCB 2017-039.
And 2017-039 and also 2018-110 as to respondent Ethelene Watson are both being recommended for dismissal for the same reason. I don't know if y'all want to vote on them together. Both of these respondents are deceased. So these cases as to them just need to be closed. The 2018-110 case involved a number of violations and a number of respondents. So if the board wants to treat these two as a block, we'll just want to make sure that their vote is clear that they're closing only the portion of 2018-110 that responds to Ethelene Watson.
So the recommendation on 2017-039 is a dismissal because the respondent has passed away. Any questions from the board? Chair will entertain a motion.
I make a motion that we accept the recommendation of the Attorney General's office.
We have a motion to accept the recommendations. Is there a second?
Second.
We have a motion second from member Jeffries. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. It's accepted 4-0 for dismissal. Next case is 2018-110. It's also recommended for dismissal.
This is a somewhat unusual case in that, it does appear that there is a violation of law by someone. The question is whether or not this particular respondent is the someone that violated the law. Her name is Sarah Brooks. She was the poll manager at Fire Station number 7 in Coweta County. There was a voter there that forgot to bring her ID and should have been given a provisional ballot rather than being sent away. That voter didn't remember who she was dealing with. She just remembers being sent away and was not able to identify the poll worker. Ms. Brooks, I believe, kind of created an inference that it might have been her by saying she did not acknowledge that she was the person that turned the person away, but she did say, well, that is what I think you should have done if such a person appeared, and that's not correct under the law. That person should have been given a provisional ballot and been allowed to return with the ID later. But in the absence of either an admission from her that, yes, I was the person that sent it away, sent that voter away, or some other evidence such as a third party witness or the, certainly the voter testifying that that's the person. We do not have a prima facie case here against Ms. Brooks that we would recommend taking this case to the Office of State Administrative Hearings to try to
Michelle,
impose the
Michelle,
penalty.
this one is Ethelene Watson. Is it-
Ms. Watson was the deceased voter that was part of this. So this case and a number of cases that we have with y'all will have one case that will involve multiple respondents or multiple claims.
Okay, so this is just relating to
So
Ethelene
this
Watson.
is, so Ethelene Watson is the one that was deceased,
Okay.
and is encompassed in the prior vote. So 2018 110 as to Watson is what we had asked to close under the
Okay.
prior vote. 2018 110 also includes a completely different claim involving Sarah Brooks, who was the poll worker who may or may not have improperly sent a voter away. But in the absence of any actual evidence, we do not feel like this case meets the preponderance of the evidence standard that we would feel comfortable taking it to the Office of Administrative Hearings to try to impose a penalty against Ms. Brooks. Or even that we would recommend a cease and desist order and a reprimand, which, although that does not involve a penalty, is a sanction against an individual. So for that reason, we're recommending an administrative dismissal in that case.
So recommendation is a administrative dismissal on this case. The respondent has passed away. Are there any questions from the board?
Be clear that this is a dismissal of Ethelene Watson as a respondent.
I may have gotten confused. I thought that the board had already voted to dismiss Ms. Watson.
Yeah.
Just did that.
Correct.
Ms. Watson's deceased. And passed away on
just-
March 31st, 2024.
This case is a Sarah Brooks, correct? The respondent is Sarah Brooks.
I apologize if I.
No, that's, no,
No, we just voted on 2017039, which was the Charmaine Swift Covington.
Okay,
And now we're talking about 2018110, which you have responded as Ethelene Watson.
okay.
Just-
That is I'm sorry, I thought that y'all had voted together with
No, we just,
prior case.
Yeah.
Ms. Watson's deceased and there's no longer a viable respondent. So the case needs to be.
the chair will entertain a motion on the 2018-110 Ethelene Watson.
Yep, I make a motion that we accept the recommendation of the agent's office.
We have a motion to accept the recommendation. Second. We have a motion and a second. Any discussion? Hearing no discussion, all those in favor of accepting the recommendation, signify by saying aye.
Aye.
Any opposition? There no opposition, therefore, motion is carried 4-0. Now, that's the last case that I have on the agenda for you.
Well, the 2018-110 involved two cases. Both of which were submitted. And we have this, often we'll have, when they come out of one county, we may have one case number that encompasses multiple respondents and multiple violations, and it can cause some confusion sometimes. So that same case number also involved Ms. Brooks, which, involves all the facts that I had previously discussed. I don't know if you want me to repeat those.
Ms., we were only given the documentation on Ms. Watson, so
I have the documentation on Ms. Brooks.
you have everyone's?
It's in my notebook.
It was in the packet that we shipped over. But if the board wishes to put it on for the next meeting, if there's any confusion about that, we'd be happy to defer it to the next meeting as well.
Yeah, what happened is I have two Ethylene Watsons, so looks like they just copied the same file and gave to me, so. I don't have, let's put the other portion of it on the next agenda.
We can just add it to the agenda for the next meeting.
Yep, okay,
All right,
Yeah.
that's all we've got. Thank you.
okay. Well, congratulations, you're out of here in about couple minutes, 22 minutes. Thank you for your
No
work.
problem.
We appreciate you. Thank you.
Thanks.
The next item on the agenda is investigative reports. The first number of cases are cases to recommend for dismissal. Let me note that case 2024-046, DeKalb County observer denied right to vote has been continued, so that we will not hear that case today. The other cases are all slated for dismissal. Are there any of these cases that the board members would like to poll for hearing?
Mr. Chair, I'd like to hear case 2022-298, 2024-156,
Hang on one second here. Okay,
and 2024-197.
any other cases the board would like to pull for hearing? Is the board amenable to voting with the rest of them en masse? Okay, let me go through this then. The following cases have been recommended for dismissal by the Secretary of State's investigators. They are SCB 2020-296, Henry County, multiple AB ballots, FC ballots sent. SCB 2020-198, Gwinnett County, Lucerne Baptist Church. SCB 2022-250, Hall County, failure by poll worker to check voter identification. SCB 2020-287, Fulton County, nursing home absentee ballot fraud. SCB 2022-288, Fulton County, absentee ballot fraud. SCB 2022-317, Fulton County, tabulation issue. SCB 2022-345, Fulton County, absentee ballot incorrect address, November 2022, GE. SCB 2024-078, Gwinnett County, multiple absentee ballots. SCB 2024-103, Gwinnett County, poll watcher conduct issues, May 2024. SCB 2024-125, Gwinnett County, voter registration fraud. SCB 2024-179, Gwinnett County, non-citizen voting. SCB 2024-184, Henry County, write-in not displayed, November 2024. SCB 2021-054, Thomas County, unqualified voters. SCB 2022-333, Fulton County, fraudulent address change. The board would entertain a motion on the above named cases. We have a motion to dismiss the above named cases. Is there a second?
Second.
We have a motion and a second from Dr. Johnson. Any discussion? Hearing no discussion, all those in favor of dismissing the above named cases signify by saying aye.
Aye. Aye.
Any opposition? Hearing no opposition, the above named cases are hereby dismissed. If you'll give me just a minute to make some notations. Yes, sir. We'll now hear SEB 2022-298 Muskogee County rides to poll. That's tab number 42 in your binders. Please proceed when you're ready.
Okay, my name is Michael Brunson from the Georgia Secretary of State's office for the recorder.
I'm sorry.
I was just introducing myself for the recorder.
Oh, okay.
My name. Got it? Okay. Okay, SEB 2022-298. Muskogee County rides to the polls. So this case was originally presented in February of this year at a SEB meeting, and it was continued in order for us to do further investigation into the two organizations that were part of the complainant's complaint. And that is Rideshare to Vote and also Lyft and their particular campaigns. So the investigator reached out to Rideshare to Vote and basically confirmed that vouchers were not given for rides, as Rideshare to Vote uses its own drivers who are volunteers as it relates to the rides, the specific part of the complaint regarding rides to the polls. Now, as far as the target, they are an organization that reaches out to Democratic voters. However, that is a separate part of their organization. The investigator actually went to the website, found a way to request or reserve a ride. He basically describes that. As he went to the website, there were several options available to request a ride. You can call in by phone, you can fill out a web form, use different or a variety of apps. He completed the web form up to the point of submitting the request. Copies of the web form pages were obtained. It's part of the investigation, Exhibit 11. At no point was he asked how he was going to vote or his political affiliation. And what he found was the experience was consistent with a statement that he obtained by the CEO during the first part of the investigation that was covered during the February 2025 hearing. Next, he went to Lyft and investigated their campaign as far as rides to the polls. He actually went to the current page and he was able to actually pull up a historical page from September 2020 using a historical web page search engine. He found that there were discount codes available for riders, 2020 Vote and Vote 24, which is under Exhibit 12 in the investigation. They were found in the public areas of Lyft's website. And also, the goal that was stated by Lyft is to help voters get to the polls. Additionally, he was able to locate multiple news articles informing the public of the available discount codes. He also was able to look at various news advertisements from various channels. And he was also able to confirm that Lyft does not contact voters or specific groups, nor do they offer vouchers for rides. So that is the further investigation that was done into both of those organizations by the investigator after this case was continued from February 2025.
Were there any questions from the board for the investigator?
Yeah, my question is Lyft provided statewide? Is it provided to every voter in Georgia?
Yes, it's open to whoever goes on their website, looks at the discount codes and goes through the process.
So voters throughout Georgia, 159 counties have access to Lyft rides?
Yeah, if they have access to the internet and to Lyft's website and see the advertisement on TV, yes.
Right. So if they have a computer and internet or a phone or that sort of access. But a rural farmer that wants a ride to the polls, can we vouch that they have access to Lyft? It's just a question, and I don't expect.
Yes, if they have.
If they have access to the internet.
Yeah.
Right.
Or TV.
Or TV, but the TV that was described in this report actually just covered Metro Atlanta and North Georgia and did not cover South Georgia or the rural areas of Georgia. So their advertising is certainly skewed to a certain part of Georgia and not to all Georgia voters. Additionally, the report states that Lyft partners with certain 501c3 nonprofits. So if they're partnering with those, then that confers that Lyft is a partner in this ride to the polls, to this voucher or this gift, a gift to ostensibly to go vote. I would like to challenge Lyft to offer a voucher for everyone in Georgia that is an eligible voter, rather than certain partners that only advertise to certain parties. I like the idea of rides to the polls, but it must be offered to every voter in Georgia to be a fair offer. Otherwise, it's a gift or a payment to vote, which seems to me a violation of 21-570. I would like to make a recommendation unless there's no further questions.
Are there any further questions?
I have additional questions.
Members of.
Investigator Benson, thank you so much for this additional work. I want to clarify. It seemed to me from the report that the coverage was actually news coverage and not advertising. Is that correct?
Yes.
So Lyft did not actually purchase advertising, so they didn't target anybody. Is that a correct understanding?
Yes, news articles from various stations, yeah.
Right, so that's what's called earned media, not paid media. So it is out of Lyft's control where that coverage may actually fall in terms of geographic coverage. I would also like to push back very strongly on the concept that if something is not available statewide, it cannot be done. Because in the case of churches, for instance, churches very frequently will provide rides to their congregations to polls, and it's absolutely untenable for them to offer anybody across the state of Georgia. Likewise, community groups can be doing this in their community to offer it to anybody. I have seen cases where elected officials who are not on the ballot that year provide rides, literally will ride through neighborhoods and pick up people in their vehicles just to take them to the polls. To suggest that the only way that is not considered a gift if it's offered statewide, that's nonsensical to me. Now, I understand that Lyft is a statewide, wherever Lyft operates, which is really dependent on the freelancers who drive for Lyft. And I don't know that there's any way to understand the scope of where those services are offered. But I think it's far more complicated than saying, oh, they purchased advertising, which is not correct. They had earned media in certain geographic areas. And that it's available statewide. I certainly hope that everybody across the state has internet access. I know that has been a major push for the state and for the federal government, or at least it used to be. And so to suggest that this is a gift simply because there's more access in some areas, I think is that's kind of a backwards analysis in my mind.
If I could add really quickly, to kind of talk
Okay.
about the advertisement versus commercial, earned and all of that. Were these news networks notified of this discount via a press release from the corporation? Do we know?
Yeah, no, I don't.
Okay, okay, so it's quite possible that these news stations were writing about this particular discount and this particular gift because through a press release, that they were notified through a press release, which would explain why the locations or the news sites that were writing about this particular situation was in the metro area. So that's quite possible too. So that wouldn't be considered earned if they send out a press release.
Well, and it's also possible that there was coverage in other areas that was simply not picked up by the investigators because that
Very
wasn't,
true.
that wasn't
Yeah.
necessarily part of what we had asked you to do. So I appreciate what you found.
Yeah, I just want to make sure if we're going to use a particular argument as a base to not do something, then we need to make sure we keep in perspective that they could have sent out a press release that would have then removed this from being earned media, no longer earned media.
Mr. President, do we know whether this was advertised in Rome, Georgia, or Savannah, or Valdosta, or Ellijay, or?
No, that wasn't the
Okay,
extent of the investigation.
so it could have been.
It could have been,
It could have been Brunswick, could have been any place in the state. We just don't know.
sure,
Okay,
yes.
Mr. Chair,
yes.
so my understanding of the report is that this was not advertised, but it was just provided through news media sources, and that the area was the coverage of the Metro Atlanta area and Augusta. Now, maybe there were other areas that newspapers wrote about rides to the polls, but it was not included in this report. And there's a difference, Mr. Chair, I beg to differ, that there's a difference between vouchers, a ticket to ride, and volunteer rides. We encourage and would celebrate churches, civic organizations, neighbors to give rides to people that need a ride to the polls. And that is what we would desire. But to have voucher systems or tickets or paid rides to go vote is considered a violation of something of value to vote. And and Lyft participated in that by providing vouchers or deeply discounted, as it's described, vouchers to go vote. So this is very different, and it may be splitting hairs, but it's very different. At the very worst, this Lyft program and their partners could be considered vote hauling. At the very best, it was just a misdirected program that offers rides to these partnership organizations that really focus on their particular voters. And I really feel that the concern to protect the opportunity for every person to vote that's eligible to vote. So if there's no further discussion, I have a recommendation.
Mr. Chairman,
Resolved.
I just want to point out that nobody received anything. They only had to pay less. They still had a voter who took advantage of one of these vouchers or used the code still had to pay for that ride. They simply had to pay less than they would have without the voucher. So they never received any remuneration whatsoever. They simply paid less. And I think that is a distinction with a difference.
I think it's important to point out that paying less is still receiving something. If another person has to pay the full price and you're paying half the price, you're getting a discount of 50%, which means you are receiving something
But anybody could have qualified for it if they knew of it.
if they knew about it, which I think that goes back to the original point, is ensuring that these organizations know that they are, if they're going to get involved with partnering with nonprofits and other organizations, and they should know that they need to make sure that their services are provided to everyone.
I agree with that.
I would challenge and recommend Lyft to, if they would like to provide vouchers or discounted rides to the polls, that they offer those to every voter in Georgia. And perhaps it could be posted on the Secretary of State's Help Me Vote website, but not on certain nonprofit partner websites that are not viewed by every single voter in Georgia.
Is there anyone from Lyft or Ride Share to Vote here today? No, okay.
Mr. Chair, to be clear, Ride Share to Vote provided information that they did give volunteer rides to the polls. So I don't have a recommendation other than dismiss the part of the allegation of Ride Share to Vote. At least that's what they reported to the investigator, that they use volunteers.
Yes.
To give voters rides. But it's different with Lyft.
And it's hard for me to differentiate between Lyft and a church or anybody else. I mean, you know, the church that's providing rides to their voters are targeting their church attendees, and you know, Lyft seems to be not targeting anybody to me, but just allowing anybody who wants to sign up to get a ride. Which I certainly think that providing access to voting is a great thing, and if they want to provide discounted rides or free rides, so people go vote. And they certainly didn't target Democrats or Republicans or anybody else. You want to ride to the polls and come get it. So
I think there's a difference between free and discounted. So if you're volunteering to do it, that's one thing. But if you are providing access to the polls at a discounted rate for some and not others, that's something different. And I think it would have been easily avoided should Lyft just had sent a notification to everyone that has the Lyft app and just say, hey, here's a discount code. If you want to get rides to the polls, they wouldn't even have to go through any partnering or working with anybody. It would have been a simple notification that pops up on your phone through the app.
well, the problem is we don't know really what was done. We don't know what they sent out. We don't know who they contacted. We don't know what pressers. We don't know a lot of
We know
stuff.
a lot. We know what they provided.
But we don't know a lot too. So it's
Mr. Chairman, I actually think that is a fantastic idea. And I think that a resolution that would require, that would include a cease and desist or an order requiring them to provide information through their app to all of their users. And I would also support linking it on the Secretary of State's website.
Yeah.
I think that would be moving forward. That would ensure that this opportunity is available to all voters.
Yeah.
So I would be in support of a solution like that.
and the question is how do we enforce that? I mean, if there's no violation of code, how are we enforcing a public company to do something?
If you tell that public company that they could be in jeopardy of violating a state code, I'm pretty sure their attorneys would make the adjustment.
Which code would they be in violation of?
What's the code you just mentioned?
570, 21-570. Giving or receiving, offering to give or receive, or participating in the giving or receiving of money or gifts, or registering as a voter, voting, or voting for a particular candidate. And they are in violation because they offered something of value to vote. Technically, they have violated election code in Georgia.
But was there a tit for tat? Was there a requirement that the person vote? Do you have to prove that you have voted, or can you simply get a discount code to go and then you can get out of the car and walk away. Do you,
Mr. Chair,
Investigator Bryan?
Mr. Chair,
Let's let everybody finish their comments and then we'll
Because
recognize each member.
that is required for a violation, that there is an exchange of goods for a service. Was there any requirement that a person who uses one of these discount codes prove that they're voting? Investigator Brunson, did you come across that at all in any of your investigations?
No,
Thank
No.
you.
just using the code, you get the discount, and then you go wherever.
Thank you.
Mr. Chair, the code
Yes.
simply says giving or receiving, offering to give or receive, or participating in. It does not say requiring proof of voting or registering to vote or voting for a particular candidate. It simply says the giving, receiving, or offering.
Well, I understand we're here talking about Lyft today. You know, are we going to require the same thing of Uber and taxi companies? And, you know, is this letter going to go out to every company in the state of Georgia that provides, you know, driving services?
I think it's a great idea to offer a ride to the polls, but it should be a common offer to every voter in Georgia. There should be a commonality to this gracious offer to every eligible voter in Georgia. And the easiest way to provide that is to put this on the Secretary of State's website, my voter page or Secretary of State, that reaches all eligible registered voters. And they would have access to that information. Every voter in Georgia would have access to that. But to allow Lyft to reach out to their customers and Uber reach out to their customers does not provide a guarantee that every voter in Georgia has the opportunity to take advantage of a ride to the polls.
If I may, and I mentioned this during the hearing in February, that we've had at least 3 cases off the top of my head. I mentioned those cases last time. I don't have them written down, in which the exact same situation involving Lyft, Uber, et cetera, was presented to the board. There was a 9-page letter written by the attorney, because all of this was discussed, very similar to what's being discussed here. And like I said, there was a 9-page letter written by the attorney where she cited federal codes, et cetera, regarding rides to the polls. So I just wanted to bring that up again in case. That's been a few months ago from that hearing. So.
And we have also had cases where candidates and campaigns have handed out gift cards, and that has been dismissed as well. So cash money has been deemed not a gift.
So I don't recall that, and that doesn't make it right.
Yeah, I disagree with that as well. But particularly when it comes to this case, I think we're in agreement that just sending them a letter, informing them to make sure that they are not in violation of Georgia code by doing these simple steps, I don't think there's anything wrong with that.
I would be in support of.
Mr. Chair, I have a motion.
Member Gazal, you were speaking?
Yeah, I was just agreeing with Member King that a letter of instruction would be, I think, inappropriate. I had not made a motion formally, but I would be in support of that. Because I do not think that there is a violation found here.
Are there any other comments from the board?
Mr. Chair, I would be in favor of a violation with a letter of instruction for this case.
Any other comments from the board? Chair will entertain the motion.
Mr. Chair, I move that Lyft be issued a letter of instruction in violation of 21-2-570 for offering, giving or receiving offering to give or receive, or participating in the giving or receiving of money or gifts for the registering as a voter, voting, or voting for a particular candidate.
Would you cite the code again?
Beg your pardon?
Would you cite the code again, please?
212570.
You have a motion to issue a letter of instruction for violation of code 21-2-570. Is there a second?
Second.
We have motion and second. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
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 Any opposition?
Nay.
The motion carries 3-1. That's pertaining to lift only. The second party in this is the ride share to vote.
I move that we dismiss that portion of the investigation.
We have motion to dismiss the ride to share vote. Is there a second?
Second.
We have motion and second. Any discussion? Hearing no discussion, all those in favor of dismissing the ride to share, signify by saying aye.
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 Any opposition? Hearing no opposition, so moved. Next item on the agenda is SCB 2024-156. The addendum, DeKalb County improper voter registration on college campus.
So this was a case that was discussed and briefed during the meeting in May of this year. There was some follow-up that was done regarding that. The case was continued. And the investigator spoke with, and this was involving Emory of Atlanta and their voting initiative and instruction given to students. The investigator followed up with Mr. James Rowland, who's in charge of that entity. She did find out, she was able to obtain the PowerPoint training slides that are provided by the volunteers or for the volunteers, and also some documents and information that's disseminated to students who are interested in voting. And looking at the documents that were submitted, it looks like another campus in Oxford had more explicit instruction as it relates to addresses. And so we shared that with the Atlanta entity, and they indicated that in the future moving forward, they would consistently use the same material so that it would be unambiguous to the students as to what they need to do as it relates to using the specific dorm address instead of just the mailing address.
Let me, before we go any further on this, I want to take a short break. I seem to recall that I might have been asked for a continuance on this from the attorney representing them. And I just want to confirm whether or not I got that, if y'all don't mind. I'm sorry, I don't have it in my notes, but let me see if I can contact him. If we can just break for 5 minutes for a quick recess.
Okay.
Okay, we'll come back in 5 minutes. Thank you. come back to order.
Mine is Gail. So, right.
Back to order. I did inquire with the attorney for that case, and the attorney wants that case to come up tomorrow when the attorney will be here to respond to it. So we're just going to move it to tomorrow. For that one first. This case on the agenda is SCB 2024-197.
Mentioned her. Who posted an individual's name and some of her information that she obtained on my number page to a Facebook post. After some back and forth about the specifics of the city of Mulberry and should be a city, that type of things. Now she did redact the citizen's information as far as her date of birth and her address. She basically wanted to make the point that this individual doesn't live here, but she's commenting on the goings on of the city. And so in looking at the statutes, the rules, there's nothing that we could find that would violate election code.
Was Paul there?
She told me she had some health problems.
Yes, push your button. Identify yourself for the court reporter, please.
Yes, investigator Jesse Patton with the SCB.
Yes,
This is the one Miss Paul had reached out that she needed to continue in order to be here and speak. Are you familiar with?
yeah, I don't recall her continuing it, but okay.
Well, not continue. She was wanting to speak and she had
Right.
reached out to the board to see if she could do that at a later
At a
date.
later date. Do it.
To move the videos until this package.
You just don't know. But Miss Paul is the complainant, and Miss Paul wanted an opportunity to speak before the board for a few minutes to just talk about the complaint itself. So even though it's set for dismissal, she wanted to be able to approach the board, so we can continue this case to the next next meeting, so. Could you reach out to Ms. Paul and just let her know the day of the next meeting and ask her if she is able to attend, and tell her that we're going to hear it regardless next time, so.
Yes, sir.
All right. That does it for our dismissal cases. Congratulations. We're going to move through those quickly. The next item on the agenda is lunch, but we're obviously way too early for that. So we're going to move on to cases recommended for letters of instruction or referral to the Attorney General's office. Are you ready to proceed, investigators, on those? Okay. First case on the agenda is 2024-199 Polk County. Illegal photograph of Cedar Town advanced voting poll location in November 2024. It's tab number 53. Oh, I'm sorry.
Okay. I'm Sarah Koth with the Georgia Secretary of State. This is case 2024-199 Polk County, illegal photograph at Cedar Town. This investigation was opened on a complaint that the Polk County Elections Director received from the polling location regarding a voter taking a picture of his ballot during advanced voting prior to scanning the ballot into the scanner. The investigator spoke with a poll manager who advised while in line, the respondent pulled out a cell phone and took a picture of the ballot. She had told him that he couldn't take the picture because of Georgia election laws prohibited it, and the respondent became irate. She stated that she showed him the code section. He still refused to delete the photo. The respondent told her that he would go outside with his ballot. She told him that was unacceptable as well. The investigator spoke with the respondent, who advised he was told to delete the photo. He did not do it when they asked, but he advised he deleted it at a later time. So the investigation was substantiated that he took the photo before he scanned it into the ballot scanner. Possible violation of OCGA 21-2568 subsection 2A2.
With the respondent, Mr. Petrinko here. Mr. Petrinko, before you come up, let me see if the board has any questions for the investigator.
Chief Investigator Koth. Yes, Chief Investigator Koth, can you remind me how we've disposed of similar cases?
Once they deleted the photos, usually the cases are either letter of recommendation or dismissed if they delete the photo.
Thank you.
Any further questions for the board, for the investigator? Mr. Petrinko, if you'd come sit at one of these chairs up here where we could get you on microphone. And press the button there in front of you. There should be a button that will make it, make it flash. No. It's not flashing yet. There you go. Okay. Well, would you, take about 2 minutes and explain your side of the case to us, if you don't mind?
So the printout is a very small print, and I was verifying my staying in line. I was trying to verify what choices I made, and I forgot my glasses in my car, and I snapped a picture and zoomed it over to better recognize the choices. Later on, clerk approached me, said that's unlawful. It was a surprise, honestly. I was shown Q&A from the website, and Q&A is very confusing, I would say. So can I take a photo of my ballot or get a receipt? The answer, no, period. You can take pictures outside of the polling area. So it may be my ESL, but it's really confusing. Can you or can you not? Later on, I found the statutory code, and obviously it's prohibited. I deleted picture, apologized. So that's the story.
Any questions from the board? Mr. Petrenko?
Mr. Petrenko, did you get paid for taking a photo of your ballot?
No,
Did you sell a photo of your ballot?
no, not at all.
Do you know that's why we don't want voters to take a photo of their ballot?
I understand that. Yes, it's explained why, but I definitely not engaged in such activity. Sorry. Stop them.
Any other questions for Mr. Petrenko?
Yes.
Member Gazal?
Mr. Petrenko, did anybody in the polling place offer you a magnifier? Because I empathize with you. I have trouble in restaurants reading my menu if I forget my readers, especially with a dim light. But did they offer, because every polling place should be equipped with a magnifier to help that sort of thing? And I know it can be embarrassing, but
No, it's actually not been offered, probably because it didn't come up. I was really, I mean, the polling clerk was really concerned about the picture itself and the fact of taking it, not why it was taken.
I
But,
understand.
Yeah, it didn't come up.
Well, in the future, for yourself and for anybody else, every polling place should be equipped with a magnifier to help you review your ballot. And I commend you for actually going through the effort to do that, because it's really critically important that every voter does review their ballot. So thank you for being a responsible voter in this case.
Thank you. Thank you.
Any further questions for Mr. Petrenko? But you're not a party to this case, so generally we don't allow comment from people that aren't a party to the case themselves, so. Okay, all right, thank you.
I would move that we issue a letter of instruction, just reminding Mr. Petrenko of the law and of other options for making sure that you can review your ballot.
Motion to issue a letter of instruction to Mr. Petrenko. Is there a second?
Second.
We have a motion and a second from Dr. Johnston. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. Mr. Petrenko, a letter of instruction, as Member Gazal stated, is simply a letter instructing you on the proper procedures going forward. Okay? Thank you for your attendance today. Next item on the agenda is ACB 2024-163 Henry County alleged fraudulent voter registration application, November 2024. It's tab number 54 in your binders.
This is continued.
This is a continued case from the last meeting. This is where the voter had two applications and she wouldn't say who the coworker was, so we went back out there. So the investigator went back to the employment and inquired as to who was possibly that worker who collected voter registration. She was given the name of August Edwards. August was interviewed and advised that she worked there for 6 months during voter registration applications through People's Agenda. She stated that she did one for Miss Edwards, but did not know if it was for May or September. She said that if she had one that wasn't complete, it would be voided and shredded. The investigator spoke with the attorney for Pro Georgia State Table, which incorporates people's agenda, and the consent authorization sheet is only retained for 90 days and then destroyed. It was undetermined if the September application was submitted by August or not. So we have potential violations, but an unknown respondent for those.
Any questions from the board for the investigator?
Did the respondent sign both voter applications, voter registration applications? I think the report says that.
Yes.
Said yes.
So we added her name as a respondent, but she's not considered one of the violations on here. So because the board had determined they wanted to ask her, but she wasn't listed as a respondent last time. So she was added.
Sorry.
So she was added as a report as a respondent, though not as one of the people with the violation. So I don't know if anyone is present.
I'm sorry, who was added?
Maisha,
The registrant?
yes. Because you'd want, I don't remember who it was, but somebody had wanted to speak with her and asked that she attend the next meeting.
This case. Are you a part of this case?
Director Mills is going to speak with her.
Okay, yeah.
Director Mills is going to speak with you for a moment. Okay. Please proceed.
I was finished.
Oh. Is Maisha Monroe? Or August Edwards? Are they here?
Mr. Chair, I have a motion.
Let me see if
She's
was that related to this case? It is. Okay. If you'll press your button again. Pressure, ma'am. Push it. If you identify yourself for the court reporter, please, and limit your comments to about 2 minutes. Thank you. Use your microphone.
Good morning. I'm Namusa Vanita Smith. The last time I was here for the hearing, May 13th, we went over this specific case, but they referred to me as the same lady, and I had to go up there and try to figure out who they're referring to. But y'all dismissed it. And when you dismissed it, you sent me a letter, and inside the letter, it was an error because
Can you give me your name one more time?
Namusa Vanita Smith.
Get that.
I was here May 13th. And we were talking about the same thing in Henry County, but it was for my daughter. So I don't know. You called me the same name.
That was a different case.
Yeah, I think. No,
Yeah, that's a different case that we'll hear.
Okay.
I'll talk to you at the break about that, okay?
Okay.
Thank you. Are there any more questions from the board in this case? Chair, to entertain a motion.
Mr. Chair, I move that we refer this to the Attorney General. Or there appears to be sufficient evidence that Maisha Monroe provided 2 voter registrations with false information.
We have a motion to refer this to AG. Is there a second?
Second.
We have a motion second from Member King. Any discussion? Here. I'm sorry.
I'm at a little bit of a disadvantage because I was not here for the May case. Can Investigator Cost, can you please explain who exactly Maisha Monroe is, what her role is? For who? Which one? Maisha Monroe, the respondent Maisha Monroe.
She had the 2 applications that were submitted.
So she was the voter.
Yes, she was a
Uh,
voter.
on whose behalf the applications were submitted. Okay.
Yes, and then one of the addresses was wrong and it looked like a different handwriting and she said, oh, I must have left that blank. The coworker put that in there, you know, to submit it, but you wouldn't give us a coworker's name and that's why the
Right,
case was
okay.
continued, so we were back.
Okay, so one of the registration applications was accurate and she had signed it and it appeared to be all her handwriting,
Yes,
correct? So, Dr. Johnson, what exactly are you alleging that Ms. Monroe did? And what code did she violate?
Evidence suggests that Ms. Monroe submitted a voter registration with incorrect information with her signature on it that she admits was her signature.
Investigator Koth, do you have the copies of the applications?
in the report, but on the last meeting though, it said that when she was interviewed by the investigator that she completed both documents. She admitted to that and then
Right.
just inadvertently, she was trying to help her, like, she said that she was trying to help her friend or whoever this coworker was get their numbers, so to
Right.
speak. And so she said that she must have left that residence line blank. And that's why instead of, she said, I don't know why she wouldn't have just asked me, I would have given her the address, but put in a different address. And that's what flagged it.
Right,
So,
and the handwriting was different for the address.
yes,
that-
and it was the wrong address.
Right.
She said she admitted to filling out both, but
Right.
she said, I must have left that part off. And then she's saying that the other woman must have just put that name in, the address. But the woman who said she was doing those registration drives said that they would have shredded it. She wouldn't have submitted it. So
And she wouldn't provide the friend's name,
Right,
so.
So my understanding is the registrar noted that the address was incorrect.
the what? Yes, that's why
Right.
it was flipped. Mhm.
So the applicant, Ms. Monroe, allowed, I don't know who filled out what, but the information that was filled out with her admitted signature on the application demonstrated false information.
Chief Investigator Koth, do you happen to know whether the driver's license number was included on the application as well? Is that information available to you?
I can pull the report and pull it up. I mean, ours was just that the address was wrong and she admitted the
Right.
filling them both out, just not
Right.
putting that in.
The reason I'm asking is because that's one safeguard to ensure that there would not have been two separate registrations for and two separate entries within the voter registration system. Because if they had matched the driver's license number, they would have at some point, if they hadn't caught the mistake as they were processing it, that would have merged the records so that there would not be an additional record.
Mr. Chair, the address that was filled in was not a street, an address nor street that wasn't located in Henry County according to tax assessor records. Nor was it located in Georgia by performing a Google map search. The word of caution here is a person should not sign a document and then leave it unfilled for someone else, if that is the case, to enter false information. The applicant should take responsibility if they put their signature on the application.
Yeah, I have very little sympathy for somebody who leaves an application partially blank, lets somebody else fill it out according to her, and then allows it to be submitted. So-
Okay. Can they not tell us?
and then won't give us the name of the person on top of that. So
I think
No, it's the last four of the social that are in here,
the last four, what?
of the social.
Okay,
Okay.
Thank
Like I
you.
said, you have somebody here who partially filled out the second application, let the friend do the rest of it, and then submitted it, and then we'll cooperate with the investigation. So we have a motion on the table we have a motion to send this to Attorney General. We have a second.
Second.
Any further discussion? All those in favor saying so, the AG signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. Next on the item on the agenda is SEB 2024-092 Henry County wrong ballot. I want to caution the board that if we continue to move this quickly, we might be out of here by lunch. So
Nothing wrong with that.
Oh, yeah, so.
please proceed.
Okay, this is SCB 2024-092 Henry County wrong ballot. This involved two complaints. The first complaint, two ICP scanners were swapped and delivered to the wrong precinct. And then the second one was an unknown Henry County voter claimed he was in the wrong district and received an incorrect ballot. So the gist of this complaint is that there were scanners that were apparently loaded onto the same equipment truck, and they ended up being switched. They were sent to the wrong precinct. Ultimately, the mistake was noticed at about 7:18 a.m. The supervisor, Joey Brown from Henry County Elections, advised that it took 20 minutes to rectify the situation. They were able to get the scanners to the proper locations. And based on that, that is a violation of OCGA 21-2-238, delivery, setup, and sealing of properly furnished voting machines prior to primary or election, in that they did not have the proper voting machine at least 1 hour before the time for opening of the polls. The second complaint, that individual was never identified. However, the investigator did speak with an individual who spoke with that gentleman, who questioned why he did not receive a ballot with David Scott's name on it. Apparently, he verified where that individual lived, and he did not live in the district that allowed him to vote for Mr. Scott. He asked the guy if he needed further assistance. He said no and left. So we never identified that voter. So that's it.
So we have two complaints. The first one that ICP scanners were 1 hour late, and then the second one was a person who claimed they got the wrong ballot and it was unsubstantiated.
Yes.
So we have the respondents, Amika Banks and Michael Winters and Hannah Hope. Ms. Banks, are you here? Mr. Winters? Ms. Pope? No, but so we'll vote on the first violation with that the two ICP scanners are swapped and delivered to the wrong precinct. Any questions from the board?
So there is nobody from Henry County here to represent the county.
Apparently not.
Did they receive notice?
And this is a continued case.
Okay.
Or not continued, it was postponed. It was scheduled for the last
Right.
meeting and then not heard.
Very good.
Yeah.
So we're confident that they received notice.
Jesse?
Yes, Jesse Patton with the State Election Board. Yes, they all three did receive notifications.
Thank you. I move that we refer this to the Attorney General's office.
For case one with the wrong scanners?
Yes.
We have a motion to refer this to the AG. Is there a second?
Second.
We have a motion and a second. Any discussion?
Yes, I want to add that I would not necessarily refer a case like this to the AG's office if the county were here to explain what they have done to prevent this from happening again. In the absence of any evidence that they're responding, I think we have no choice.
Any further discussion?
I have to agree. I would have given a letter of instruction, but the lack of response suggests that we should refer this to the Attorney General.
Yes.
We have a motion and a second to refer to the AG. All those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. Carries by 3-0. It's on the agenda is SCB 2024-022 Henry County Security of Election Equipment. It's tab number 56. You bind it.
So this is the same county, Henry County, and in this situation, they had election equipment in a room that apparently the lock was malfunctioning. They ended up having an event at that location, and they discovered that it was unlocked later. Ultimately, they did get the lock fixed once this incident occurred. And so basically, we recommend, or we found the preponderance of the evidence to indicate that they violated Rule 183-1-12-0.05, security of voting system components at county elections office or designated county storage area.
Any questions for the investigator? Once again, is Amika Banks available? No. Chair will entertain a motion.
Yeah, I agree that if they're not here to support their side, I recommend that we send this to the Attorney General's office.
I second.
We have a motion and a second to send case number 2024-022 Henry County Security of Election Equipment to the Attorney General. Any discussion? Any discussion? All those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. Investigator Patton.
Yeah.
Were they notified of this case also?
If I may.
Yes.
So 092, I don't think you all dealt with the second part of it.
Oh,
Oh, that's right. Yeah, I think we should dismiss.
Yes.
The second allegation?
Second allegation.
Yes. Mr. Chair, I move that we dismiss the second allegation on 092.
Second.
We have a motion and a second to dismiss allegation number 2 on SCB 2024-092 there. Any discussion? Any discussion? All those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. Allegation number 2 is dismissed.
Thank you for that reminder.
Did you find it? We were notified.
Do you mind checking the next one too, 073? Just to make sure that that's also Henry County.
Go ahead and begin that. SCB 2023-073 Henry County City of McDonough redistricting issues 2023. The respondent in that case is Henry County Elections and Registration Officer Mika Pitts once again.
Did we already conclude the first? Did my motion pass? Send it to the Attorney General's office?
The first two is the third one, yes. Okay.
Thank you.
The 073 case.
Yes.
Okay. And we have confirmation from our investigator that they were notified.
Okay.
Okay.
So this was a self-report from Henry County that a street in Hamilton Point subdivision in the city of McDonough should be in City Council District 2. However, it was listed as City Council District 3 in Jarvis. The Overo Street segment was placed in City Council District 3 in election map prior to the merge, now known as Jarvis. It is indicative that a clerical error was most likely made, but it is unknown which Henry County election employee made the change since the change was made in ENAT prior to the conversion. It was presumed that during the redistricting that the municipal council district was inadvertently changed to District 3. All of the other adjacent streets, Hamilton Point Drive, Mooring Avenue, and Culloden Moore Drive in this subdivision are listed in the proper City Council District 2. The investigator checked each registered voter on Overa Drive and confirmed that none of these voters voted in the 2023 general municipal election. There is evidence to suggest that Henry County Elections and Registration violated OCGA 212226 subsection B.
Any questions from the board for the investigator?
Yes, Mr. Chairman. Chief Investigator Hoff, do I remember correctly that the county actually did move to remediate this as soon as they learned of the problem and instructed that voters be provided provisional ballots in order to try to correct for that? Am I remembering that correctly? And they self-reported in this instance?
They self-reported after it said a resident named Mr. Cook, but we never could identify who that was.
Right, and the list of registered voters were sent to Heritage Park Polling Precinct, informing the polling manager to provide any voter on the list a provisional ballot. So in this case, they did everything they could once they found the problem, but again, they're not here to explain that. So under normal circumstances, I would be very likely to simply send a letter of instruction and thank them for self-reporting and for remediating at the moment, but it's really hard to do that when they're not here.
Right. I'm questioning whether or not they intend on showing up after lunch since they were actually on the schedule and we have moved at warp speed this morning. So investigator Patton is going to find out whether or not they were planning on being here this afternoon. And
No, I mean,
yes.
I agree, it may not make a difference, but I just, it would be helpful to know if they had planned on being here after lunch. But let's move forward anyway.
Then in that case, I would, I move that we defer a final decision on this until this afternoon. We can.
until we get in contact.
We're able to get in contact with him.
I mean, what, if he does get in contact with them and they say, oh, we're on the way now, does that constitute? I mean, will we accept that?
We can, well, it's up to the discretion of the board.
Okay, I mean, removing personal responsibility is always a concern of mine. If you got the letter, you know to be here, you know what time it starts, assuming that your case is gonna come up at a different time is irresponsible, particularly as a county. We would not do that for a citizen. So I think the county should be held to a higher standard.
And there were a number of Henry County cases on the dismissal too, so. Right. Is there a motion on SCB 2023-073?
Yeah, I make the motion that we send it to the AG's office, due to just them not being here.
So we have motion, is there a second?
Second.
We have a motion and a second by Dr. Johnson, send this to the AG. Any discussion? Hearing no discussion, all those in favor of sending this to the Attorney General's office, signify by saying aye.
Aye.
In opposition, hearing no opposition, so move 4-0. Next item on the agenda is SCB 2023-037, City of Braswell, failure to hold elections. It's tab number 58.
The allegation that the town of Braswell violated the law by not holding elections from 2013 to 2019 was unsubstantiated. The city of Braswell advertised and held qualifying periods at each election interval as required by the law in 2015 and 2019. According to the law, if there are no opposing candidates, the single candidate is considered to have voted for themselves and a notice of election cancellation is published. The town charter mandates that the city hold elections every 4 years. However, the investigation revealed that the city of Braswell, along with Helen Waters and Richard Fennell, did not complete the required postings for the 2023 municipal election, fixing and publishing fees, which is a violation of OCGA 21-131 subsection 1A. They also failed to designate and open for qualifying on the qualifying period days as specified in OCGA 21-132 subsection 3A. Furthermore, the city did not hold a municipal election November 7th, 2023, which violates OCGA 21-9. This information was confirmed by City Clerk Helen Waters, who stated that she informed the mayor in December of 22 of her desire to resign from her role. However, no official documentation of her resignation was obtained. Potential violations for City of Braswell, Helen Waters, and Richard Fennell, the mayor, for OCGA 21-131, OCGA 21-132, subsection 3A, and OCGA 21-9, subsection C.
Are there any questions from the board on this case for the investigator?
It's true. I believe the city is represented.
Oh. The respondents in this case are the City of Braswell and Helen Waters, City Clerk. I assume you're from the City of Braswell? Okay.
Can you hear me?
I
Yes.
can hear you now, yes.
Good morning. My name is Samuel Johnson. I represent the city and the mayor. I do not represent Helen Waters.
Could you tell me your name again, please?
Samuel Johnson,
Samuel Johnson, okay.
and I'm the city attorney.
Would you like to respond to the?
Yes, so the city has retained my services to ensure that the city complies with the obviously the laws and specifically with the election laws. As a result of this, city has conducted an investigation. I've conducted an investigation, and we've determined that Helen Waters did obviously fail to provide those notices or conducted. Helen Waters was subsequently terminated from her position. We hired a new city clerk. Obviously, the city has hired an attorney to oversee the election, ensure that there is an election, ensure that the laws are being complied with. There will be a special elections coming up. We have provided notices. We are seeking the help of Polk County to do a special elections. And we are looking at a consultant to help us with the upcoming election. Obviously, I wasn't involved at the time when this happened, but I have personally been involved in getting the city back on track, making sure that they do a special elections to fix the issues. They have given notice to they have done the publications, the notices, and everything else. So we are working on getting a special elections and making sure that this does not happen again. And number one, number two, that would fix the problem, getting the seats properly elected.
Any questions for Mr. Johnson? Any questions for Mr. Johnson?
No.
Would you push a button? Are you associated with this case? Okay, would you identify yourself, please?
My name is Raymond Martell. I'm a resident of Braswell, and I've actually been trying to run for mayor for Braswell. And for one thing, they're saying about this city clerk, Helen Waters. Of course, they're trying to put blame on her, but of course, the mayor, Richard Fennell, he's been familiar of all of this. And so just kind of put all the blame on her isn't really, he was her boss. But when I made it known that I wanted to run for mayor at a previous city council a couple months ago, the city actually went as far as to retaliate against me. I was a lieutenant for the police department. I resigned in January. And when I made that announcement at a council meeting that I was interested in running for mayor a couple months later, my resignation on post was actually changed by the police chief to a termination only a few days later, which put my post certification under review. And basically, I submitted paperwork for interest in running for mayor the next time there's an election, and I have not received any type of notification. I haven't seen any kind of postings, nothing. They have a city website. They don't ever post anything on the city website. They don't ever post they cancel council meetings without any notice. They reschedule them without any notice. They don't make meeting minutes available to the public. It's just a whole host of issues.
Yeah. Yeah, I mean, it sounds like there are a lot more issues than what we're here to deal with today, that you certainly could file those complaints and we would investigate those.
Yes, sir. And I don't know exactly what the best process is, but I've sent in letters to the Secretary of State's office, the Attorney General's office, as far back as February, February of this year, and I have not heard anything back.
Yeah, your best course of action going forward would be to send one to Executive Director Mills.
Okay.
Okay. Do you have any?
So we do have the mayor here. We do have the new city clerk here. We do have city council and the police chief. They are all here in case there needs to be anything responded to. However, as far as his comments go, he's not part of this case. He's just a citizen of the city. He's not part of the case at this point. And as I said, the notices have been published. We are working with Polk County to ensure that there's a proper election, there's a proper special elections, and those seats are properly filled. Helen Waters, who was the city clerk at the time, the city had relied on her to ensure that those city, and she was the voting superintendent. They relied on her to ensure that those notices were sent out, that those steps were taken. However, it wasn't. Helen Waters had indicated that she was terminated on December 22nd, December of 2022. However, Helen Waters was actually terminated on June 27, 2025. So she was recently terminated, and that was based on several people's recommendation, including myself.
So she was terminated in 2025.
Yes,
She was terminated 2 days ago
June.
or last month.
Yes,
So
June
30 days
27,
ago.
2025.
Okay.
So on July 1, 2025, a new city clerk was sworn in, who will be handling the elections. And as I said, the notices have already been published and sent out.
Did any of your other party want to make comments? Would you press identify yourself, please, and
Yes, good morning. I'm Joseph Jefferson. I'm the chief of police in Braswell, and I've been here 10 years. And to rebuttal what, in reference to Helen Waters, the mayor did his due diligence in investigating this ever since the issue came about as far as not having an election. Now, I specifically remember Helen stating in council that she had already filed the paperwork, did everything that she needed to do in order for us to have an election. Well, when the heat hit the fan, we found out that it obviously had not been done. That's when she mentioned, well, I told them that I wanted to resign because I was too old or something to that effect. So that's when I told her, I said, well, Helen, you're lying because you sat here in city council and specifically told us that you had filed all the proper paperwork to have the election. And I told her that, and there were some people there in the council meeting. I think Bartell was there too as well. To rebut against what he's saying, this has nothing to do with retaliation on him, none whatsoever. That's something's totally different from the department why he was terminated. On two separate occasions, we had an ongoing investigation. So, like I say, that has nothing to do with this election issue that we have. It's just that I seen some of the issues, even though I wasn't the mayor, I seen some of the issues that was obviously taking place that should not have taken place. I know Helen's not here, but Helen just was not doing her job. None whatsoever. Totally disqualified for doing it. Mayor did his due diligence and terminated. And so this is why we are here, not because we are just Braswell, we're just trying to do something underhanded or just because we feel that we want to or don't have to have an election. We're on up and up. We hired an attorney. We have a city manager, a clerk that's doing her due diligence, that knows this city in and out as far as how things are supposed to be done. And so that we won't have this problem moving forward.
I'm curious. So Miss Waters didn't post the things, but y'all didn't notice at the time that nothing was posted? The city and
I'm sorry, say again.
Miss Waters did not make any postings, didn't post anything. She told the city that she had posted stuff, but apparently nobody noticed that nothing was posted.
No one checked.
Obviously not. I mean, she obviously, as bad as it may sound, she obviously was just lying about it to all of us.
But she was lying, but nobody noticed that she was. I mean, you have to post these things publicly, right?
Well, I mean, yeah, we noticed that's why I started complaining. We complained to the mayor, and we looked into it, and that's how we discovered that, hey, you obviously did not do what you're supposed to do, because we got the letter in the mail at some point from the State Board of Election inquiring about our election, why we didn't have the election. So that's when the mayor asked her at council meeting, we got this letter. What is the deal with this letter stating that we had not had an election and filed paperwork? You told us that you did it. And she kind of chuckled when she said, yeah, y'all are worried about nothing. I've already filed the paperwork. It's already being done. And so at that point, at the end of the year, about, I think it was the first of 24, that I had started to inquire about it. And again, at that time, she said, yeah, I filed it. Well, this year, I think it was the first of this year, during council meeting, we inquired about it. Some citizens was there, and Helen, for some reason out of the blue, said that she had told the State Board of Elections that she was too old and wanted to resign from their position. And I'm like, well, that's the first. because that's what I told her. I said, Helen, you told us, I said, you're lying. I said, you told us that you filed the proper paperwork for this election
When did she tell you that?
this year.
So it took 2 years to discover that the paperwork wasn't filed, that nothing was posted?
Yes, ma'am. I don't live in the city, but I'm not making excuses
Yeah.
about anything, but it's just that I know we have elections every 4 years.
Wow.
But like I said, this is my first time. I mean, we've never gone through anything like this here before, but it's just that at that point where we started realizing that, she's obviously not doing her due diligence. She's telling us one thing and telling whomever else, whatever else she's telling them.
Who does Ms. Waters report to?
The mayor.
Is the mayor here?
Yes.
Okay.
Okay.
Oh,
I'm sorry.
I hope the county election director is also here. So just to be clear, basically what we're dealing with is we trust but didn't verify. So when she told you that I'm assuming, I guess I'm a little confused. So when it all happened and the election didn't take place, or it just didn't happen, no one inquired, like it just came up 2 years later. Like there was no one found this to be weird.
Well,
There was nothing.
well, you gotta understand, Miss Waters has been doing this for several years, so they had relied on Miss Waters to do it as she did in the previous years, previous elections. So
Okay.
that's why they had trusted her to do it. And this is when she dropped the ball and she actually didn't do it. So in the past, she had done the correct things, and that's what they relied on.
Okay, so they just didn't verify.
Yes.
Okay.
Obviously,
Election-
this is why now I'm here to ensure that going forward, things are getting done properly. And number two, it gets fixed through a special elections that's coming up.
This is my last point. This is my last point. I do think it's important to note that this is not just a failure from the city clerk. This is a failure of the city, because the fact that it was never viewed, no one looked to see if these documents were actually posted. I mean, especially if you're inquiring about it, then you probably should look for it. So that's a concern. And I do think that this is not just on one person.
I understand, and obviously the city takes this very seriously, and going forward, things will be changed.
Yeah, I think I have the same concerns. I appreciate that y'all are taking these steps to correct everything in the future, but the fact that she didn't do her job and nobody seemed to realize that she didn't do her job. City council didn't realize, the mayor didn't. Nobody seemed to recognize that she didn't do her job. I'm kind of shocked there wasn't an uproar before now about it, frankly. Member Gazal?
I would like to ask if the county election director, Mr. Beck, had anything to add to this conversation.
Stan, I'm Noah Beck for the reporter. I'm the county elections director for Polk County. The city of Braswell is actually a split jurisdiction, which is kind of important for context. It's one of the 5 cities that have boundaries inside of Polk County, but it is split between me and Spalding County. Deidre Holden, the election director for Spalding County, intended to be here as well today, but y'all are moving incredibly diligently today, and I've got a lot of respect for that. I know that it typically takes a little while to get through some of these things, but the new city attorney and the new city clerk have reached out to me about conducting special elections in 2025. To the point that no one noticed, I feel like I did. I would like that to go into the record. I did, and that is why I believe I am the complainant on record for this file. I would not let the citizens of Polk County that live in the city of Braswell to go without their right to an election. And so I did make the complaint and then urged that it be included prior to the 2025 municipal cycle so that it could be dealt with. I do want that out there and on the record that we were intending to get this dealt with as efficiently as possible. I would recommend that the investigation file, I believe, is going to have interviews from several complainants that have been seeking relief from a plethora of sources over the last decade. is going to have interviews with them. At my recommendation, I passed their contact information along to the investigations team. I would urge the board to review those interviews. There's a lot more besides the election compliance, as you've heard here today, that you may crack into and hear about. My chief concern, again, similar to yours, is that there was supposed to be an election in 2023, a year after my tenure started in Polk County, and there was not. Now, I can't speak for anything beforehand, but I do know that those interviews go deeper into the context of everything going on. But it is my concern that that Polk County citizens get fair and equal access to elections when they're entitled to them. And so we do intend, under advice of their counsel, to advise and consent. We are not conducting their elections. I would like that clarified. We're not conducting their elections. Neither is Spalding County. They're going to act as their own municipal election superintendent under the direction of the Polk County Board of Elections with advice and consent. And that is that we will not be conducting their elections. There's questions of compliance, of course. And I believe that this case should be split into two. What I tell them is today forward and yesterday back. I think y'all are looking at the yesterday back. I'm looking at the today and forward. And I think that there are complicated questions to ask and answer about yesterday and back. But I do want to ensure that we're trying to figure out the best way to navigate the special elections, the 540 elections for November of 2025 to fill vacant seats on the city council and ensure that proper elections are conducted in the future if they are necessary. So I wanted to assure the state election board that they have reached out. The Polk County is going to be as helpful as we can be. We believe that every Polk County citizen, city of Braswell citizen or not, deserves free and fair access to the elections they're entitled to. So 2025 November hopefully will not be issues. We've already started working towards compliance, but I do encourage you to review the file in depth because there are complaints that people have been trying to raise and get relief for much longer than my tenure here in Polk County. And I think that a lot of them merit review. And I'll also take any questions about how we've navigated this over the past 3.5 weeks as well, as far as getting them closer to compliance.
Thank you, Mr. Beck. Mr. Johnson, has the city considered contracting with either Polk County or Spalding County to actually conduct the elections? Because that would move the liability to the county and off of your plate. Now, you would have to pay for those services, obviously, but that would be moving the responsibility and therefore the legal liability off of the city and onto the county.
We have considered that, and we would be willing to do that. I think the problem is not the city, is the county who does not want the liability. So that's why we had decided to do it on our own. However, I am planning on bringing it up in the next city council meeting to get approval for a fee to hire a consultant, a private consultant to do the election, to help us do the election and just walk us through it. So and I believe that he's aware of who the consultant is, and we're working on getting the payments for that. Strict.
To his point, I individually, in my individual capacity as Noah Beck, not Noah Beck, election director, believe that jurisdictions inside of a county conducting the elections for the municipalities upon request is compulsory. I do believe that if a city reaches out to a county government, that they are obligated and to conduct that election, and Braswell, being a split municipality, has the ability to forum shop with us or Spalding County. But I will tell you that Spalding County's Board of Elections, as well as the Polk County Board of Elections, have taken the stance that it is a legal liability for us to conduct the elections of the city of Braswell. At the time, that's why the solution was sought out of them acting as their own municipal election superintendent under the advice and consent of either Spalding or the Polk County Board of Elections and Polk County volunteers. So that kind of answers that. And I know there are a plethora of election consultants out in the space of Georgia right now, all of which would be capable of assisting the city of Braswell in 2025 and in the future after we see what comes of this. But as far as that goes, yeah, I believe it's compulsory as well that Polk County should conduct it if it is the will of the city of Braswell. But I understand my board's concern with the legal liability of on taking such a process with such unique circumstances.
Are there any further questions from the board?
Would you be willing if we strongly encourage you to take on an active advisory role? Is that something that you could take back to your board? I mean, it's not something that we can force, but something that we could strongly encourage, with acknowledging that the actual conduct of the election is going to be undertaken by the city.
Yes, we would happily do that. We've actually already self-inflicted that one, if you will. We've taken on the responsibility, like you said, they hired a new city clerk that I was familiar with from a position that she was in prior, and we were excited to get to work with her. We've been working with her over the last three and a half weeks or so to get them in compliance for the special elections that we believe are necessary to fill vacancies. Then there are still questions to be answered about, well, what about the positions that should have been elected in 2023 and so on and so forth. And like I said, today forward and yesterday back, kind of having to compartmentalize to survive this one. But we have already taken on that advisory role, and we've done that kind of in conjunction with Spalding County as well, keeping them informed of every step along the way. I also share a split municipality with Joseph here over in Bartow County, and so I'm not completely foreign to how to conduct one across county lines. And so we're working alongside DJ as closely as we can to make sure that gets done properly.
All right, you've received your strong encouragement.
Yes. Only one last comment for the record, which is our jurisdiction is limited to Title 21. It seems to me that there are significant issues in other titles, and there would be other fora for reviewing those. We are strictly limited, and I think Mr. Johnson's been very good about keeping the focus on elections here in this forum. While we may wish that we could help support folks pursuing other possible violations, we're really focused solely on this one title.
As a city attorney, I wish I could go back in time and fix problems coming forward, but obviously I can just do what I can from here forth, making sure that the city is in compliance with all the laws and rules and regulations.
Mr. Chair, if there's no other questions, I have a motion.
Dr. Johnson has a motion.
I believe there's sufficient evidence to suggest that there have been violations of OCGA 21-131, 21-132, 3A, and 21-9C. And I recommend referral to the Attorney General.
Motion to refer this case to the Attorney General. Is there a second?
Second.
We have motion and second. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved, referred by vote of 4-0. Thank you for attending. Next item on the agenda is SEB 2022-189 McIntosh County, problems at the polling place. This tab number 59.
This was continued.
Huh?
It was continued from last week.
Yeah, it's a continued case from the last meeting.
So this case was briefed in its entirety during the last SEB meeting. There were numerous allegations, 12 total, and we found cause on 4 of those allegations, all related to McIntosh County and their treatment of poll watchers. So before a decision was rendered, there was a request to look at the history of McIntosh County and their violations before a ultimate decision is made. And so all the board members should have received a document that recounts the various cases along with the decisions from those cases. So in brief, there's a case 2020-061 in which there was a Attorney General consent order And this is regarding a citizen who did not receive her absentee ballot in the mail. There was another SEB 2022-046 in which a voter took her 12-year-old daughter with her, and the worker basically said that she couldn't have her daughter there. An LOI was given in that particular case. The next case is this case, which obviously has not been, a decision has not been rendered on. Another case, SCB 2022-202. And an LOI was given in that case. And that was when a voter was required to include a copy of her driver's license with her absentee ballot when she tried to use, I think it was a CCW permit. I don't think that's in the, but I remember that presenting that case. So LOI was given in that case. 2016-015 was dismissed. 2020-284 did not involve the county. It was a voter taking a photograph. 2021-097 did not involve McIntosh County elections. It involved McIntosh County Superior Court. 2021-112 did not involve McIntosh County. It involved two citizens. I think one of the citizens brought a complaint in this case. 2022-203 was closed in investigation. 2022-241 was dismissed. 2023-060 is still pending. 2023-090 did not involve the county as a respondent. Another photograph taken case. And then finally, 2023-037 was dismissed, and the allegation was not sustained. So that's the rundown of the history of McIntosh County and cases.
So yeah, it's Eleanor Dahl-Gill or anybody else from McIntosh County here as a respondent?
Yes, sir. Can you hear us? We're on Zoom.
Our investigator is.
Yeah, I just wanted to let you know that Jason Nix said that he's the county attorney. He's willing to respond. He wanted to be on Zoom call and he's left his phone number, but he's not here in person. He offered to respond to
Via Zoom?
via Zoom or via cell phone number.
Do we have has he been sent the link? Was he,
Hello?
can we get him up live?
I'm here on the Zoom now.
Okay.
Can the board hear me?
Jane, you want to turn up your screen? We can see it.
Oh.
You should be able to see it on your screens.
Yes.
Nope, I see me on there.
There you go.
Can the board hear me?
Yeah, you'll be able to see it on your screen.
Microphone check, 1, 2.
And who is online with us?
Hello, can you hear me now?
Yes.
Hi, my name is Jason Nix. I'm the attorney for the McIntosh County Board of Elections and Registrations. And I also have with me Eleanor Dahl-Gill, our supervisor of elections. She's sitting just outside the frame of the camera.
Okay.
We were the ones who were there at the previous meeting in person, and we appreciate, Mr. Chairman, that you offered to allow us to appear by Zoom this time because of the minor nature of the questions that needed to be investigated before the board issued a ruling on this.
Well, it's a lot hotter in Atlanta than it is in McIntosh. I'm surprised you don't want to come up here. So
I don't know about that. I might have to contest that fact.
you're near the ocean. You can at least go get in some water. So Do you want to respond to these allegations?
Yes, sir, and I'll respond briefly, but if you need a further response, because I responded in detail during the last meeting when we were there in person. The issue that was brought up by Mr. Gardner at the last hearing was he was basically complaining that there had been multiple letters of instruction that were being disregarded by the McIntosh County Board of Elections, which is absolutely false. And the two prior letters of instruction were actually part of the set of cases that were scheduled to be heard during the previous Zoom meeting, fully online meeting of this board, that this case was part of that, and it was continued at his request from that hearing. So it would have been heard all at the same time, absent his request during that original Zoom meeting of this board or video virtual meeting of the board. As stated by your investigators, there's about 12 allegations. Allegations 1, 2, 4, 5, 8, 9, 11, and 12 are all recommended by dismissal by your investigators. We join in that. There's no evidence to support those allegations. We understand, as I addressed last time, that allegations 3, 6, 7, and 10, they're really all the same issue. It's an issue regarding the scheduling of poll watchers at the opening and closing of elections. It's not an issue going forward because we've clarified this with the party and with our poll workers. But the issue that happened on that election is the party was trying to did designate more than 2 people per precinct, and statute only allows 2. So we discussed with them coming up with a schedule. So they submitted to us an explicit schedule listing who, where, and when. And their explicit schedule detailed exact start and stop times for each person, which included the exact time of the opening of the polls and the exact time of the closing of the polls. That led to some confusion. It is not an issue going forward. It has been rectified. We understand that anybody can be there to observe as long as they're not disrupting during the opening or closing of the polls. But the issue that happened on that particular time was they were trying to do more than 2 per day per precinct, and they had exact start and stop times that they had provided to us, and we just strictly enforced that until it was clarified and verified that evening with Ms. Gale. And then at that particular precinct, they were allowed to remain. But we acknowledge that there was a mistake there as to that issue on those 4 allegations.
So you admit 3, 6, 7, and 10.
As it relates to restricting poll watchers from observing the setup and teardown of the polling precincts, yes, there was a violation in that regard on that day.
Mr. Nix,
Yes, ma'am.
did you educate or provide some instruction as far as the ability of poll watchers to take photographs of tabulation tapes after the polls have closed?
That has never been an issue. That's not what was alleged in here. What was alleged in here was an issue of taking a photo of the tabulation on the machine during the closing process, not the tabulation tape outside. No one has ever restricted the taking of a photo outside of a precinct, outside of the building. That is absolutely public space. And at no time have we ever restricted someone from accessing the public air inside the building. If you'll actually review, I think that was item 10. Particularly, they were talking about how people were still voting. And I don't even think the allegation makes sense factually. I think that's why that's part of the sort of not really part of the one we're having an issue with there. But again, it wasn't about the actual tape outside of the building. That was not an issue.
Mr. Nix, as far as allegation number 6,
Yes,
Mr. Daniels was told to go outside and they locked the door. So that's been reviewed and a corrective action taken.
We don't believe the door was locked. He was told to go outside. Corrective action has been taken.
And in allegation number 6, the poll workers telling the poll watcher he could not use paper and pencil. Has that been corrected?
Yes. I believe his wife is present there at your meeting, but Mr. Daniels, Johnny Daniels, has passed regrettably.
And Mr. Nix, are poll watchers permitted to take a record of the vote counts on the scanner while they're performing their poll watcher duties?
Somebody's scanning a ballot.
As long as it's not disrupting the process, as long as they're not like blocking someone from submitting their ballot into the scanner.
Correct. Okay. So they can read the numbers that are on the ballot marking devices and the number on the scanner to make sure that they are reconciling the votes each hour or period of time that they're assigned.
Absolutely.
Thank you.
We have somebody here who would like to respond also, ma'am. Would you identify yourself, please?
Sir, I'm Linda Daniels. I was the past chairman of the Republican Party and also some of the teachers and head up with the training of the poll watchers. Plus I worked as a poll manager and worker for years. Our people were not allowed to watch the opening and closing. They were issued outside, not in just one precinct, but several. And they were not allowed to go look at the machines and see the numbers. You're given a chair and you sit back there where you're told to sit. You do not get up and you do not speak to a soul. And that was after we were allowed to have pencil and paper to write some of the numbers down. So some of these things are maybe worked on and corrected. The problem with the designated time, we have a lot of elderly folks. And to be there for 13, 14 hours is harder for them. So we divided the clarity of being able to watch the polls open. That should be available to anybody, not just a watcher. And they were not allowed to do it. And I was some of the ones that followed some of the ones. Appreciate your time.
Thank you. Thank you.
She hasn't worked in you.
Okay. Would you identify yourself, please?
Yes, sir. I'm the one that made a complaint. I'm Tim Gardner. Thank you for your time and been here last month. But I would like to say that what he said was untrue. They do lock the doors and they do not let you in. I've got, if you go back and read the history of it, they accused me and they admitted they locked the doors last month they was here, or in May. I had to go to court. The officers had to come investigate me. How come I could not open the door and they let a county commissioner in? And that was the whole complaint. They let a former county commissioner in to go in there and view the situation. I had to run everybody else out, and I couldn't open the door. They said I was shaking the door too hard, so they called the law from Glenn County to investigate. He dismissed all charges right on the spot. But that was the reason why the doors were locked at 7 o'clock on the dot. Poll watchers was asked to leave while there was still people voting. Before, and this is in some of the findings, before the last ballot was cast, all poll watchers were asked to leave. So that's, this is what's going on. And I understand they come back and say it's been corrected. It's always to come back for permission or forgiveness, that vary the permission. That's what we see here a lot throughout this years. And so I just want to clarify that it was locked. I was unable to come in. The people was with me was unable to come in. That's when they called the law. I got called law too, so I know. I got a police report to that effect. I mean, it's not a hearsay, it's a fact. And I want to address this. This is an ongoing citizens thing. And there's other cases coming up that's pending still, like he said. And I got a call yesterday on my phone from a county commissioner said that a registration of his son, which has nothing to do with this case, I'm trying to keep it, but he want to know how to go about presenting it to y'all. And so I'm going to advise him to come and send it to state election board for review. Because his son's registration, he lives in another county and it's still coming to his dad's house and he's 38 years old. So there's a problems going on and we need to address this. And that's what I want to clarify. The doors were locked and I have documents state that I was, investigated for that purpose of shaking the door too hard.
I recall your case.
Sir?
I recall your case. Yeah.
And I was just concerned about the way it was, and I was not allowed to take a picture of the polling slip. That's nothing. They said we was allowed to take a picture. We was not allowed. That was the purpose of me wanting to go. I said, let me see. I actually won that district. I actually won all the districts the day of election. So I just want to see the number. No, you can't do that. You can't. So they refused me. That was some of the aggravation at the time, and so we addressed that, like you say, remember that case.
Yeah, I do.
We didn't go no further than that. Thank y'all for y'all's time.
Thank you. Any further questions from the board? Chair will entertain a motion on this.
I move that we issue a letter of reprimand that would include a cease and desist that makes it very clear that should we see a repeat violation of any of these, in particular with granting access to poll watchers appropriately, that there will be a referral to the Attorney General's office with any further violations.
We have a motion to issue a letter of reprimand with the stipulation and any further violations will go to the Attorney General's office. Is there a second?
I'm debating whether we should just send this to the Attorney General's office because it seems like there's several violations over and over again. And I'm wondering if, they had already received some letters of instruction in the past. Oh, sorry.
You're on. You have to.
Sorry. No, what I'm debating is whether this should go to the Attorney General's office now. There were letters of instructions that were sent previously, and I wonder how many letters are we going to submit, before we take it to the next level. 'Cause it doesn't seem like they're following, or that's my concern. That's what I'm debating in my head.
Well, I'm willing to.
Madam Chair Member, may I?
Yes.
Just in response to the issue regarding previous letters of instruction, I wanted to highlight again that those cases, as this board is quite aware, there were a lot of cases that y'all have brought on that had to handle a backlog, a very substantial backlog. So these prior cases, these other letters of instruction were all part of the same pack of cases that were all being processed by your board at the exact same time. They were all scheduled on the same day. They were not prior. We did not receive a letter of instruction and then disregard it. These have all been received by this office this year. This is all from years ago. This was 2022. So it's not that there have been disregarded letters of instruction, not by any measure whatsoever. These were all cases held together. And this case would have been held that same day as those other cases that the letters of instruction were in, if not for the request for continuance by Mr. Gardner or his attorney at that time. So, and we've tried to address them as quickly as possible. So I don't think that's a valid issue going forward, but I just wanted to make sure we were clearing the record up on that issue.
But you're also stating that what Mr. Gardner referred to, you were shaking your head as if that wasn't true, what he was saying.
Correct.
So there's still confusion.
Much of what he has said is inaccurate, factually. And several of the things Ms. Daniels asserted, we disagree with factually. Now, as to the issue with not allowing the poll watchers to watch the setup and tear down on that particular day in 2022, that is a legitimate issue that has been rectified. It was rectified the very next day, or even that evening, really.
Okay. Okay, I don't mind. I can second.
We have a motion and a second to issue a letter of reprimand with specific instructions that if these actions continue, that they will go to the Attorney General going forward. Any further discussion?
Yes, Mr. Chair. I would have, considering the number of violations, 3, 6, 7, and 10 in this case, specifically about the ability of poll watchers to observe election processes or the election conduct concerns me. And I would prefer that this go to the Attorney General because of the number of complaints and violations. It was helpful to have the investigators provide previous cases involving McIntosh County. But I'm concerned that poll watchers' rights are not being permitted as they should. And I suggest that this is more of a problem that McIntosh County needs to seriously address and rework how they consider poll watchers as part of the whole election process, so that that voters can have confidence that the elections conduct and administration is being performed legally and correctly. That's my preference with this case.
Any further discussion from members of the board? We have a motion and a second to issue a letter of reprimand with the specific instruction that any further violations would be referred to the Attorney General. Hearing no further discussion, all those in favor signify by saying aye.
Aye.
Aye, but if this comes up one more time, I mean, I have zero patience for it. Right. So,
Any opposition?
Nay.
Vote carries 2-0. Motion carries 2-0.
1, 2 to 1.
I'm sorry, 2-1. 2-1. I'm getting hungry. Thank you very much, McIntosh County.
Thank you, sir.
If there's anything else on there for you, so. All right, thank you.
Thank you.
So next case, sounds pretty easy.
I do want to state for the record, if you don't mind, for the record, I do want to state that by doing it like this, it does keep us involved in this process so that we can watch it, sending it.
These citizens, the last few days of ballot or without individual citizens had nothing to do like the election people, not people. Ballot and the other, just they were sorry, system. And they don't know if you go around or they said, we can't do nothing about it. All you said there is that vote over that farm citizen. But I can show you that yesterday. You going to, you tell me what to do this. I said, I'll be there tomorrow, I'll help somebody. But this is commissioner, it's concerned a lot of people, it's kind of like, it's another little difference, is, if we visit all. And that's,
Yeah.
I guess.
We're watching it.
Thank you. Thank you. Let's, we're going to try and do one more case before we have our lunch break. We have, SEB 2022-185 Bryan County districting issue. It's tab number 60 in your binders.
Okay. It was brought to the, is it on? Oh, it was brought to the attention of the Bryan County Election Office that 8 addresses were placed in the wrong district during the redistricting process. Out of the 8 addresses, there were 22 voters. However, only 6 voters voted in the May 24, 2022 general primary election. The investigator spoke with Cindy Reynolds, the Bryan County election supervisor, who explained how during the redistricting, they missed a small portion of addresses near I-16. They utilized and relied on Arlo during redistricting, which indicated they were in the correct place. However, they missed the addresses. Ms. Reynolds confirmed that 8 addresses were missed, which came out of the 22 voters, and 6 of those voters participated. This case was about Pamela Gunter ran for District 1 Board of Education against Sean Page. Pamela received 572 votes, or 48.06%. Sean Page received 618, which was 51.93. If Miss Gunter had received all 6 votes from the voters who were not properly redistricted and participated in that election. The percentages would have changed to 48.32 for Gunter and 51.67 for Page. If all 22 voters had voted, which they had not, the percentages would still be 49.01 for Gunter and 50.99 for Page. The potential violations are for the Bryan County Board of Elections and Registration, Cindy Reynolds, the election supervisor. And there's evidence to suggest a violation of OCGA 21-226B, which is about the duties of county board in determining eligibility of voters.
The respondents are Cindy Reynolds, election supervisor, and the Bryan County Board of Elections and Registrations. Are they here today?
Mr. Chair and the board, William Deal on behalf of Bryan County and the election supervisor. We do have a new election supervisor that has taken over that role. We're here today. I mean, the allegations that the investigator has reviewed are accurate. There was a mistaken process as we were going through the redistricting process. A piece of that was in reliance on some mapping software or digital data that we had. But ultimately, they did miss one street. That street, as you heard, impacted 8 addresses, ultimately 6 voters. As I mentioned, we can't dispute that issue happened. Why I'm here today is in part coming hat in hand, but also to convey to you that we have also made intentional and very appropriate steps to remediate this to make sure that this issue does not happen. So previously, the process that was in place did have oversight and it did have kind of second review. Clearly, that wasn't sufficient. Now, with our current election supervisor, we have multiple touch points, multiple people that are reviewing each redistricting to make sure that we are not just matching with some of the digital data, but the actual legal descriptions that we have. And so that is the process now. We have multiple touch points, multiple people reviewing it. And that has really kind of made sure that we are accurately redistricting, actually accurately reflecting the redistricting. Also want to mention that our new election supervisor has looked through manually all of the redistricting to make sure that this issue did not occur anywhere else. We have not seen any circumstance where it has. It was limited. This is one particular road. So there are 8 addresses on one road that is just on the periphery of a district. And so again, we have made steps to remediate. We have been very intentional and very purposeful in making sure that we have background and support. But this was an error, and that error, obviously is not acceptable when we go through elections. But this county has absolutely gone through the process to make sure that this does not happen again.
How did it occur? I mean, what's your best?
So as best as we've been able to figure out, that the former election supervisor was looking through a map, and the map just either came right up to this address and didn't catch everything, or this particular road was missed. Had the actual legal descriptions, and we looked at actually kind of the meets and bounds and the calls of this district been implemented, it would not have been missed. But as we understand it was really just looking at the map, and a line came close to this road. It was unclear which side the road fell on.
Okay. Any other questions for the board? From the board?
I'm not sure if you can help me remember, but the redistricting process in this last cycle was really messy in Georgia. We had to go through several rounds and litigation and then last minute redistricting. Do you know whether or not these maps were part of that?
Really? I don't believe that these were County Board of Election maps. I think it came down from the General Assembly, is my understanding.
And
so
that's where the messiness came from.
And yeah, absolutely. There can be a little bit of confusion there with the maps. But I think that it was actually a digital error as opposed to just reading the local legislation.
Was it a single street segment that we're talking about?
Single street section.
Any further questions from the board? The chair will entertain a motion on Case SCB 2022-185.
Mr. Chair, I move that we dismiss this case.
We have a motion to dismiss. Is there a second?
Second.
We have a motion and a second from member King, I believe was first. Any discussion?
Mr. Chairman,
Member Gazal.
I will support this in large part because the county came hat in hand, provided their explanation and provided a good explanation of the remediation that has already been done. So as a lesson to any other county that is called up here, this is how you do it. Right. Thank you.
Correct.
Thank you. Any further discussion? Any no discussion? We have a motion and a second to dismiss this case. All in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. This case is dismissed. We can try one more. We're gonna do one more. I saw that frown and groan and SCB 2022-035.
It's a continued case.
Oh,
It was.
it was a continued case. Yeah, it's tab number 61.
Heard.
Okay, so this case has been presented twice now. And during the last presentation in May, there was I believe it was a motion made that the respondent was to show up and to swear, I believe, that she did not sign the voter registration document. So basically, that's the only piece of this case that's hanging.
Is she?
online?
Are they online?
Yes, this is Don Forsyth, Sarah Rampton Forest.
They'd asked to participate by
Virtually.
Yep.
Can you hear us?
There they are.
Yeah.
Your screen.
Okay.
Can you hear us?
Yes, sir. We can definitely hear you. This is Don Forsyth here, Sarah Rampton Farr's husband and attorney. And thank you. Just wanted to say thank you to your board members for allowing us to do this virtually today because it's a long drive from Brunswick and I really appreciate it. And if y'all have any questions, we're here.
I do remember, I know Dr. Jan, this was something that you wanted her to basically swear that she did not sign those documents because there was a lot of confusion around whether that your handwriting, I mean, it's very similar, but personally, I did see some error, some differences. And so that's why you're here today.
It seems to me during the last session we had that you didn't dispute that she might have filled out both of them, but there was a dispute as to whether a check mark was made in her handwriting because it didn't appear to be the same as X's that she had made on the other one. But there was you didn't dispute that she might have filled out both of those.
If the board recalls at the last meeting, the investigator reported that the form was actually filled out apparently at the Glenn County Public Library in downtown Brunswick. The library was automatically registering people to vote. And when my wife met with the investigator, she did say that the signature, her signature was very similar to her own, and she thought it might actually be hers. But the rest of the form, there were inconsistencies that Board Member King had pointed out, and the rest of the board members had noticed at the last meeting that the way that my wife had checked box and the way that she wrote her numbers, specifically 7s and 4s, was completely different than her own handwriting. And I remember it was conclusively believed by the board at the last meeting that y'all agreed that it wasn't her that filled out the form in question and compared to her own handwriting. And the purpose of today, excuse me, today's meeting was that she would come in. Board Member Johnson had asked that she come in to give testimony about this.
I don't think the board agreed conclusively that she didn't fill out both of them. I think that the board agreed that there was some inconsistencies in the first one and the second one, and specifically the inconsistency I saw was the check mark itself that did not appear to be the same as what she had done on the other one, because she put X's on one and there was a check mark on the others, and that part itself was relating to whether or not she was a United States citizen, I believe. I don't have those before me right now. So the question was whether somebody else might have filled in that part for her. But if I recall correctly, it was unclear as to whether she might have, filled out the one at the library when they were just registering people. And, that might have been, in my mind, a possibility that she may have done both of them, but not completely filled out the first one herself. So.
Yeah.
Mr. Chairman, if I may.
Yes, absolutely.
There's a question on that form that says, are you a citizen? Yes, no. I was not a citizen and I did not say yes. And if you pay attention, that marking that square was done outside of the square. When I met with your investigator, voluntarily, I gave handwriting samples. I never check outside of a square. And it's stupid for me to claim that I'm a citizen when I was not. I just went to the library for getting my library card.
I believe you. I believe you did not check that box. That's my personal belief, okay? Because that didn't appear to be consistent with what you'd done in the past. What I stated was that you may have, it's my belief that you likely filled out the form, but did not fill out that section of it stating that you were a citizen. Okay? That was my conclusion. I came from looking at all your handwriting samples, all the forms, that you did not fill out the part stating that you were a citizen. Somebody else checked that. That was my conclusion from all documents I looked at.
That's what, in summarization, that's what I meant at the last board meeting when I came to Atlanta, that it was the opinion of the board members who were present that it was your opinion that the rest of the form, not Sarah's signature, but the rest of the form looked like it had not been filled out by her.
Yeah,
well, I don't know about that. I mean, the rest of it looked fairly consistent to me, but like I said, the check marks itself did not look consistent to me. And I don't believe that she filled out that portion of the form. So,
and even the numbers, board member King at the first meeting had pointed out the numbers appeared different, which my wife had pointed out to the investigator as well. But sorry to keep interjecting like this.
I understand. I could understand somebody who's not particularly familiar with our voting system coming in and filling out two different forms. I mean, I understand that happens. I do believe that she didn't fill out that first portion relating to citizenship. I do believe that.
But I only have one question for Ms. Ramdafar. When you were at the library, did they just hand you over a bunch of forms and have you complete a bunch of forms?
Well, Mrs. King, it happened in 2019. I mean, I don't remember anything other than I went to the library just for getting my library card in Brunswick. And I am 100% sure I did not say that I am a citizen while I was not. I mean, my husband is a criminal defense lawyer. I'm a physician. I have good fluency and literacy. I mean, why should I claim that I'm a citizen while I'm not? I mean, does it make sense to you? And just as a confirmation, I met up with your investigator, Mr. Monroe, if I recall correctly. Yeah. And we talked about the handwriting and the differences. And to my eyes, I mean, and I have a very obsessive mentality, I figured out there were other consistencies as well. So I don't think it was just my signature. I think it was other parts as well that was totally filled up on my behalf while I was not there for any kind of registration for voting. I just went there to get my library card.
I still stand in the same position that I do believe that this wasn't her that filled out that middle portion. It does look very different as far as how she checks her boxes, and that was something that stood out to me. So I'm ready to make a motion. I don't know where everyone else is.
Let's see any other comments from the board.
So, Ms. Ramdafar.
Yes, ma'am.
Do you swear under oath that you did not sign a voter registration application?
Yes, ma'am. Yes, ma'am. I
Oh, can y'all hear
swear.
us? Oh, mhm.
That creates a problem for me.
Why?
Because I would believe that she did not fill out those boxes. But I also believe that she filled out that application, at least partially, the first one. And if she's swearing under oath that she did not fill out any of that application, that creates a problem for me. So.
Do you mean, did she complete the application form, or was it her signature? Because if you're asking if she signed the document, I mean, what she's arguing is that she did not fill out the form, that she did not try to register to vote. Yeah,
My conclusion is that she partially filled out that first application in the library. That she did not state she was a citizen, but she partially filled out that application. Okay. That's my conclusion. And therefore, if she swears under oath that she didn't fill out any of that form, that creates a problem for me.
Mr. Chairman, I understood.
Yes.
I understood Ms. Ramsey to be saying that she did not swear to being a citizen.
Right.
Is that, did I understand you correctly in saying that you were swearing that you did not assert that you were a citizen?
Yes, ma'am.
But that wasn't Dr. Johnson's question. Dr. Johnson was asking her if she swore she did not fill out that application.
Sign.
Sign the application, yeah.
Mr. Chairman, if you recall last session, your own investigator said that in the library in McIntosh, they were automatically registering people who were going there for library cards. In Brunswick.
I'm sorry, I didn't get any of that, hardly.
My wife was re-emphasizing that at the last board meeting, the investigator had said that the library was automatically registering people to vote. And that's where the whole thing comes into question. I mean, of course, the board meetings are available on YouTube, and my wife and I have gone over the video before. That's why I speak so matter-of-factly when I was talking about recollections from the previous meeting. But as far as my wife knows, when she went to the library, she was signing up for a library card. Any sort of documents or any other forms that may have been put in front of her, she thought was just in furtherance of getting her library card. There's no way she knowingly attempted to register.
Yeah, I think we're talking right past each other here.
Fraud requires specific intent.
Right.
And it is my belief that Ms. Ramtafar did not have any intent to register to vote. She did not have any intent to assert citizenship.
I agree with you, but Dr. Johnson asked her if she swore that she didn't fill out that form. That creates an issue for me. If Mr. Ramtafar said, yeah, I might have filled it out, but I didn't allege that I was a citizen, that sounds reasonable to me.
Mr. Chairman, to my opinion, there are discrepancies in my handwriting with what I was offered by Mr. Monroe as your investigator. To my eyes, this is not my handwriting. That form is not my handwriting. It was a copy. It was copied from my handwriting, but I see discrepancies there. Okay, that is my testimony. I did not fill out that form that was shown to me by Mr. Monroe.
You didn't fill any part of it out.
No, that is not my handwriting. This is my testimony.
Yeah, the only thing that she said at the time was that this handwriting on the signature looked like hers. And she and I have discussed it, and that is what we concluded is that's the only part that matched, except for the or just her handwriting. Sorry, there's an echo that with the feedback that we're getting here, but that was the only part that we realized or that we identified as matching hers was the actual signature. But as board member Gazal had pointed out, and my wife never had any intent to register to vote. I mean, as I said, she simply went there to get a library card. As far as she knows, that's all she ever did at that time. And as Ms. Gazal pointed out, it is the law that a person has to have the requisite intent to commit fraud. That's always the basic element of committing fraud.
Mr. Antompar, you speak English very well, and I assume you read very well if you're a physician. Did you read the voter application that states that you must be a U.S. citizen to sign a voter registration application?
In the library, you mean, ma'am?
Yes, in the library. In the library.
No, ma'am. I mean, yes, I read it. I read everything carefully because I told you before, I'm a physician. I have this obsessive mentality. I read everything carefully, and I never sign anything before reading it carefully. I mean, my husband is a lawyer. You see, it's impossible for me to sign something without reading it. So that form that you see in front of you under my name that says, "Are you a citizen?" and yes, it is not me. I mean, I can swear that it's impossible that I fill out a form saying that I am a citizen while I was not.
To the citizenship aspect, I mean, like I said, this is where I think there's a communication breakdown with my wife. Is as far as she knows, she did not fill out a registration form to vote. Correct?
Yes, that's correct.
Yes, I mean, any other document that may have been given. You were not aware that it was for registration purposes, correct?
That's true.
You thought everything that was presented to you that day was for the sake of getting a library card and solely for getting a library card.
Correct.
Okay. That's the point we're trying to make. Like I said, my wife, she does speak English very well, and she's under stressful situations, of course, I always have to make sure what's being asked and what's being answered is understood, because her native language is Farsi.
This was 6 years ago as well, correct?
Yes, ma'am.
So my original question was, do you swear under oath that you did not sign a voter registration card back in 2019?
Yes, ma'am, I swear.
To the best of your recollection, correct?
Yes. And I am 100% sure I did not claim that I'm a citizen while I was not.
Because this gets into a tricky question when you're asking if she filled out a registration form, because she wouldn't have knowingly done it. And so to the best of her knowledge, she did not fill out a registration form. And I mean, like I said, that's not barring the possibility that a librarian who was automatically registering people handed her something to sign that was that she thought was part of the library card process. I mean, like I said, this is going back to 2019, which is 6 years ago. And I mean, I'm sure, Sarah, if you could answer, I mean, every form that the librarian handed you, you were not, it's not at the peak of your memory.
True.
I mean, the matter was only investigated in, 2023?
Yes.
Yeah. I mean, we've been cooperative as can possibly be. We've been to 3 meetings, and I mean, it's clear that my wife never had intent to register to vote. She was well aware she was not a citizen, and she...
And to be clear, you did not vote in that election either, did you?
No, ma'am.
The only time she voted was after she became a citizen in June of 2022, which was in the following election cycle. And like I said, from the last meeting that we had, where I attended in Atlanta back in May, it's surprising. I mean, the chair of the board, he sounded quite conclusory at the meeting that he did not feel that my wife had completed the form. And like I said, we can review it on YouTube. It's still there. And now, I mean, it's in question again. I
Chairman's looking at over something. That's what's taking a little minute.
I see.
That's the 2019 form. Y'all want to see this? That's the 2019 form. What's the 2024 form? Those to me appear to be the same. But same signature. The question is that doesn't look right to me. Okay. The rest of it, maybe it appears to be substantially similar.
But it does. I mean, the writing's very similar.
Well, it could be copied.
7. I'm not an expert, but it looks it looks.
You answer when it comes.
Should come for the board.
Nope.
Chair will entertain a motion.
I make a motion that we send a letter of reprimand that just signifies that this is something that is that was taking place. The signature as well as the top portion of the registration form is very similar to the writing sample. Where we do have confusion is when it comes to the box, checking the box. It does appear that in the samples, the boxes were checked with X's, whereas the registration form was checked with a check mark, which is different. So so in order to move forward, a letter of reprimand will be sent out. That's the motion that I would like to put on the table.
We have motions or a second? There's a motion and a second. Any further discussion?
Mr. Chair,
Yes.
in this situation, voter registration by a non-citizen is a violation of election law. I just want to go on record that the handwriting, I'm not a handwriting expert, but this handwriting looks very, very similar. And the only area of question is how a box was checked or Xed on the application, but the voter registration application is in English. It's easy to read. It's not, it doesn't say library card application. It says voter registration application and has the requirements for, the necessary requirements for registering to vote in Georgia and the US. So it appears that that this application was signed by a non-citizen, and I would prefer that this go to the Attorney General.
Any further discussion? So we have a motion and a second to issue a letter of reprimand on case number 2022-035. All those in favor signify by saying aye.
Aye.
Any opposition? Dr. Johnson, how'd you vote?
Nay.
Nay. Vote carries, motion carries 3-1. Thank you very much. You can disconnect them, please. The chair would entertain a motion for a lunch break at this time.
Actually, Mr. Chair.
We have motions or a second? All those in favor signify by saying aye. We will break until 1 o'clock. 1 o'clock, we will resume. Thank you. We'll leave it on. Okay. All right.
There wasn't. Yeah. Okay. Oh, 2023-060. The legal assistance. So I don't know the gist of the case. They only summarize the ones that are complete. It's 2023. Oh, 23. Oh.
Which room is
060.
Should be on.
Oh. So we received a complaint that provided information that the Spalding County Board of Elections and Voter Registration had improperly disqualified a qualified elector. This occurred during the Spalding County General and T-Spot election held November 2nd, 2021. Mr. Rapp said he requested a paper ballot and was denied by the elections director, Ms. Slaughter. Mr. Rapp said that a clerk, Mary Passmore, was in the office that day, that he was denied his vote on paper ballot. Ms. Slaughter had advised she later contacted the county attorney regarding her decision. Ms. Slaughter advised that she was of the opinion that OCGA 212385A that she could allow them to vote in person at the elections office by absentee ballot. Ms. Slaughter advised she did allow each elector to vote in person. Ms. Slaughter said this was still during the early voting period. She also advised that after casting their ballots, placing them inside the 2 envelopes and signing the outer oath affidavit, the electors turned their ballots into the Board of Elections office clerk, Mary Passmore. There was another voter, Glenda Henley, who had also requested a paper ballot, was denied, and then allowed to vote an absentee paper ballot in person. So Ms. Slaughter advised that she and her staff did not upload the credits in the state eNet system as required. She said this was overlooked due to many reasons, to include only one returning county election employee, medical issues with some election employee staff, and almost an all-new Spalding County Board of Elections and Voter Registration Board member. Ms. Slaughter was correct in initially denying the 2 electors' initial request for the paper ballot because there was no emergency circumstance. The investigator also found evidence to suggest that Spalding County elections did fail to enter the statewide voter registration system for qualified voters, Darrell Rapp, within 60 days of the primary election. The eNet report that was run, it did not show he was given credit for the Spalding County General and T-Spot election held November 2nd. This investigation also found that he requested the paper ballot and voted by absentee per his signed AV ballot oath envelope. The investigation did find evidence to suggest that the Spalding County Board of Elections and Registration Supervisor did fail to enter into the statewide voter registration system within 60 days for Glenda Henley and Mr. Rapp. So violations for OCGA 21-235A for allowing them to vote with the paper ballot when there was no emergency, and then violated OCGA 21-215I when she failed to enter within 60 days. So it's kind of 2 different.
So the violations are OCGA 21-2-215I.
Yes, for not putting them in within 60 days. And then she was right in her initial assessment where she shouldn't have allowed them to vote by paper ballot, but she did. And they came back. She called them, they came back, then they voted. And so that really was a violation of OCGA 21-235 subsection A.
235?
21-2-35.
The violations here. Well, the violations are the same on potential violations.
Well, it was for 2 different people, but she did it twice. So she kind of created her own when she allowed them because there was no emergency circumstances that would have allowed paper ballots to be used.
Right, but it's not listed. You don't list 21-235A as a violation under here.
Oh, I don't. Well, the report didn't cite that one, but it was a violation, which is why I pointed it out in my summary.
Yep. So are you recommending a violation of 215I and 35A
Yes, those are potential violations.
on both cases?
On both people, yes.
On both people, okay. The respondent is Kimberly Slaughter. Is Ms. Slaughter here? There you go. Ms. Slaughter, you want to?
I'm not Ms. Slaughter. I'm Stephanie Wyndham, attorney for the Spalding County Board of Elections and voter registration. And Ms. Slaughter would also like to speak. But first of all, this complaint alleged that a qualified elector for the November 2021 election in Spalding County had been disqualified improperly. And that is not the case. Neither of these electors were disqualified improperly or otherwise. Their votes were counted. The election director for Spalding County, Ms. Kimberly Slaughter, began work in this position in August of 2021. At that time, there were 2 part-time employees in the office of the Spalding County Board of Elections, and neither of which even had an email address for Spalding County. Ms. Slaughter began the job of staffing, organizing, and inventorying an office that could only be said to have been in utter chaos. She also began her training to meet the requirements of Georgia law, which she completed in January of 2022. During early voting for the November 2021 election, 2 electors demanded to be allowed to vote by paper ballot. And you'll hear the details of these interactions, to include Ms. Slaughter's communication with Blake Evans and his staff. You'll also hear that neither of these voters were disqualified, that both of their votes were counted, but because of uncertainty as to how to categorize those voters in their voter participation history, and there were other exigent circumstances such as a COVID outbreak in the office, and the matter was not fully resolved until April 3rd of 2022. The voters' votes were counted, but they did not reflect as cast in ENET within 60 days of the election, and we certainly acknowledge that. Again, the alleged violation was that a qualified elector was disqualified, and that did not occur. While there are technical violations and that 2 voters were not entered into ENET within 60 days of the November 2020 election, no qualified elector was disqualified. Both voters' votes were counted, and the circumstances were very unique, giving their not just requests, but demands for paper ballots. The staff in the elections office was all new, and this was their first election. Further, nothing like this has happened since, and the Spalding County Elections Office has provided excellent service to the voters of Spalding County. This was an anomaly in almost too many ways to count. And after you hear from Ms. Slaughter, it's our hope that you will agree that this is an anomaly. It has been addressed by the Spalding County Board of Elections and Voter Registration, and it is not something that has happened since or is likely to ever happen again.
Thank you. And Ms. Slaughter?
Yes, good afternoon. So I just want to detail a little bit more in depth so you can see the full story of what happened. On October the 13th, 2021, I was notified after returning to the office that Daryl Rapp had been waiting to speak with me in regards to not being able to vote by a paper ballot. Ms. Preston, voter registration coordinator at that time, had encountered Mr. Rapp, who had not accepted her answer in reference to voting a paper ballot, and stated that he would wait for my return. I then visited the Athletic Hall of Fame, which was just right up the sidewalk from our office, which was used for advanced voting. Asked Mr. Rapp, did he mind stepping out to speak about his concerns. I then informed him on in-person voting how it takes place during advanced voting. He stated that he had voted in person by paper ballot in the last election, which would have been in 2020. That was prior to my arriving to Spalding County as election supervisor. In all honesty, there were also a few phone calls which took place between Mr. Rapp and myself in regards to this issue. I do remember that Mr. Rapp was adamant that he should be allowed to vote by paper during advanced voting hours. I did explain that the only paper ballot voting to transpire during advanced voting would be absentee by mail and a provisional voting, and that provisional voting would not apply because his eligibility vote was not in question. OCGA 21-2-383C was also shared with Mr. Rapp, as this is the law guidance our office utilizes for voting in person during absentee voting. Next day, October 14th, I was phoned from the advanced voting site, again, Athletic Hall of Fame, by the voter registration coordinator that there was an additional voter who wished to vote by paper at the advanced voting site. I informed Billy Preston, voter registration coordinator at that time, that I would be there to address the issue. I proceeded to research and find OCGA once more 21-2-383C, which states that in-person absentee voting takes place by an electronic device, and took the code book with me to share with the voter. And this was with the voter was the former Board of Elections and voter registration member, Miss Glenda Henley. I listened to her concerns and explained that the only paper ballot was a provisional ballot, which again did not apply to her because her eligibility to vote was not in question. After two identical encounters with the same exact situation, I decided on October 14th that it would be the best interest of the office and voters to reach out to the county attorney, whom contacted the state and spoke with, at that time, Sarah Beck, attorney for the state elections department. There was then a memo in reference to advance voting submitted about paper ballot. I was actually shocked at the outcome. And I was shocked at the outcome at my past experience in elections and voter registration. I witnessed the implementation of the advanced voting law, and we never did utilize paper ballots at that time. However, I did realize the law OCGA 21-2-385C that Ms. Beck and Ms. Wyndham have referenced was indeed contradicting to OCGA 21-2-383C. I phoned Ms. Henley and Mr. Rapp both, apologized for the confusion, informed them that they could vote a paper ballot, which had been directed by the Secretary of State's office. A table with privacy inside our main office was set up in order that those wishing to cast an in-person paper absentee ballot was able to do so. I phoned a neighboring county to share this news because it was a concern to me that many other counties may not understand that the state was requiring to put this in place. I believe that the word was passed around as I received a couple of calls from other counties who did not understand the decision by the state. On October the 19th, 2021, at approximately 10:50, Blake Evans, along with Sarah Beck, phoned me to let me know that a mistake had been made in the decision mentioned above and directed me to rely on OCGA 21-2-383C, which is the code our office initially relied on, and that it stated in-person voting should take place utilizing electronic ballot markers. I requested that they please put this in writing to me for my records, to which Blake Evans replied that they would probably post something on Firefly, on BuzzFeed, on Firefly, to which they did so. This should be also, all of this information should be in the investigation and should have been in your paperwork as well. Both voters, Glenda Henley and Darrell Rapp's votes for the November 2nd, 2021 election were counted. There was never any question, any doubt in our minds that these votes should be counted. What came into question was how to credit these voters. Each voter's paper ballot was processed the same way as a mail-in absentee voter's ballot would be processed. Both voters' unopened oath envelopes were released to the absentee ballot clerk, and it was noted that the number of ballots included 2 in-person paper ballots. Also, our reports from the election management system reflected a total of 215 votes were cast, which matches the number of oath envelopes secured from the counting of absentee ballot oath envelopes. In closing, please note that I became election supervisor in August of 2021, as mentioned before, and inherited an office without hardly any staff at all. I can assure you that we take very sincerely a person's right to vote and what votes should be counted. So what I hope that can be taken away from this today is that first and foremost, that we understand everything that happened, and that I would have never made the decision to do or to conduct an in-person voting in our office if I had not been guided by the Secretary of State's office to do so. Also, there was confusion about the credited for voting because it was not an advance in-person vote. It was not an absentee by mail vote, and it was not an election day vote. So there was guidance needed by the Secretary of State's office of how this should be credited. Also, last but not least, of course, is to bring attention to these two laws, which still contradict one another today. OCGA 21-2-385C and OCGA 21-2-383C are still presently contradicting each other. My hope is that this moves forward to our legislators for legislative correction. Thank you.
Thank you, Ms. Slaughter. Appreciate those comments. They're very helpful. Any questions from the board for either the investigator or Ms. Slaughter or the attorney?
Ms. Slaughter, have you made it clear now to all of your staff and to your voters that the only pathway to vote on a paper ballot is to apply for an absentee by mail ballot and have that that will be sent to their home or to a temporary out of county address?
Yes, that never was an issue. We were taking direction from the Secretary of State's office.
I understand that, and I well, thank you for coming and explaining that. And I would like to underscore and reiterate your plea to the legislature. The code needs a complete and total rewrite. There are numerous provisions in here that apply to systems that have not been used in Georgia in decades, and it's extraordinarily confusing for attorneys. So how can we expect that voters can actually know what's expected of them? And the law is there to provide guidance to citizens on what is appropriate behavior. And if we can't figure it out, if attorneys in the Secretary of State can't figure it out, we cannot expect the voters to be able to do that. So it has to happen. It will take a very long time. It will probably have to take more than one legislative session to get this done right, but we've got to start working on a complete and total rewrite of our election code.
Any other comments from members of the board?
Yeah. Ms. Slaughter, thank you for your explanation. And I was reading those two very codes last night, scratching my head and wondering which one takes precedent over the other. Which way does it permit an absentee ballot or a vote to take place by a requester? So I appreciate your explaining what happened and confirming that that the circumstances are very understandable, and the issue about issuing voter credit in this situation and recognizing that the voters did indeed cast their ballots, that when the time is right, I'd like to make a motion to dismiss this.
Any further comments from the board? Chair will entertain a motion.
Mr. Chair, I move that we dismiss this case 2022-026.
Is there a second?
Second.
We have a motion and a second. Any discussion? Any discussion? All those in favor of dismissing this case signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so move. This case is dismissed. Thank you, Ms. Slaughter. Y'all have a nice trip back. Now, which other one's yours?
12. What's the next one after?
One after this.
165? Oh, well, let's go ahead and do that out of order then, so we can let you get on your way. We're gonna hear SEV 2021-165, Spalding County absentee ballot dropbox.
This was a complaint about, the complainant advised they went towards the window when they were trying to turn in their absentee ballot. The employee instructed them to put their ballot in the drop box, and they did. They are concerned that their vote, as well as the votes of any other electors who were instructed to put their absentee ballots in that drop, may not have been counted. This was a complaint, further stated that according to SB 202, the drop box should have been closed following the end of early voting. This was November 2nd, 2021. The investigator reviewed SB 202 regarding the closing of drop boxes, which is addressed in OCGA 21-2-382C1, confirming that drop boxes are required to be closed at the end of the early voting period as outlined in OCGA 21-2-385D1. Mrs. Bentley informed the investigator that the drop box located at the Spalding County Board of Elections and Registration used during early voting was still available for use on November 2nd, 2021. She said that the box, as she was instructed by an employee behind the glass to put her absentee ballot in the drop box, and she did. She decided to send an email to the elections director of the Secretary of State, the matter of the drop box use because of what she had experienced. The investigator corresponded with Ms. Slaughter initially via email and then on a telephone call. Ms. Slaughter explained to the investigator that the circumstances surrounding the state of the Spalding County Board of Elections and Registration Office of the fall of 2021. She stated that she had assumed the duties in August 5th of 21 and that the sole employee of the office was a seasonal employee. She made it clear that she was not offering, but she acknowledged and accepted as an error on the part of her office as an excuse. She indicated that she took immediate notes of this error and made the office aware of the correct procedure for future elections. Ms. Slaughter advised the investigator that her office never directed a vote to put their absentee ballot in the drop box, which contradicted that statement. The potential violations for the Spalding County Board of Elections and Registration violated SB 202, which is outlined in OCGA 21-382C1.
So the Dropbox was out there and it was available for people to put their
Yes.
votes in after early voting was over with.
Yeah.
Correct?
Correct.
Good. It was located in the lobby. Any questions from the board?
Did they want to speak?
For the investigator. No. Did you want to make a statement on this one?
Yes, sir, please.
Is it going to be shorter than the last statement?
Much shorter, yes.
Okay, all right.
So there is conflicting information as to whether or not this absentee ballot was, as to why this absentee ballot was placed in the drop box on that particular day. And the complaint definitely originated out of fear that the complainant's vote had not been counted. And the fact that the drop box was accessible to the public after early voting had ended prior to the November 2021 election is undisputed. We do not dispute that that drop box was there and accessible. We're not exactly sure what the definition of closed is according to the law, but we admit that the drop box was accessible. And while the elections director does disagree that her staff instructed this voter to place their ballot in the drop box, we do concede that the accessibility of the drop box on that particular day is a violation. And Director Slaughter will address the actions that have been taken that were taken to immediately remediate the issues, as well as the fact that nothing has happened like this again since 2021, November of 2021.
Is Ms. Bentley here? No complaint? Okay. Ms. Slaughter?
So yes, a little bit shorter than last time. Accept responsibility. And I do think, again, we could look at that law and address what does close a drop box mean. We remedy the issue by making it unavailable. It's not even in our lobby as I speak to you today. It's in the lobby when it should be in the lobby during advanced voting dates and times. Ms. Bentley, again, a different former Board of Elections and Voter Registration member for Spalding County, was the one who placed that ballot. And of course, the ballot was counted. We accept the responsibility of that, and correction was made right away. But I stand by my employees, one and a half that I had at that time, and that no one ever directed anyone to place it in the drop box. In fact, it is an option for voters and will be until the law changes, if it changes, but we wait on our voters as they come in the door, and we are there to accept their ballot from them. So no employee was ever instructed to tell someone to drop it in the drop box, and no employee ever told anyone to drop it in the drop box. So That's all I have. Thank you.
Did you say Miss Bentley was a former member of the board?
That is correct.
And did she make a complaint at the time to y'all about the Dropbox being out?
No, called the Secretary of State's office.
So she never said anything to y'all about it being out there, never made a.
No,
Just
no, sir.
applied to the state automatically. Okay. That seems odd, but.
Mr. Chair, yes,
Yes.
I found it odd. I find it curious that a board member would use the Dropbox and not know whether it could be used or should be used, or should have been after advanced voting was closed, and not bring it to the attention of Ms. Slaughter at the time to correct her very short term as a supervisor, right? You've been moved to that position about 10 minutes before? Felt like 10 minutes. Right, and with your meager staff. I just wondered why a board member, Ms. Bentley, did not correct that at the time and immediately filed with the Secretary of State.
Ms. Bentley is not just a former board member, she's a former board chair and was well aware of the chaos in the office.
Thank you. Any further questions from the board? Chairman, will entertain a motion?
Mr. Chair, considering the circumstances of the new hire and the situation of 2021 and Ms. Slaughter's immediate response to have corrective action with handling drop boxes, I recommend that we dismiss this
We have a
case.
motion to dismiss. Is there a second?
Second.
We have a motion to dismiss and a second. Any discussion? Hearing no discussion, all those in favor of dismissing signify by saying aye.
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 Move resolved.
In this case, I would have supported a letter of instruction because there was a clear violation that was admitted, but I am in the minority here.
So how do you vote? Move resolved.
Nay.
No. The chair's going to exercise his right to vote and will vote aye for the dismissal. I think it's unbelievable that we have a board chair that pulled that stunt. So.
Thank you very much.
Thank you.
Thank you. How long we drive is it back to Spalding County? Yeah, but you're going to get out of here before you hit the traffic. So good luck with that. Thank you. The next case on the agenda is SCB 2021-168. That is the City of Lyons absentee ballot fraud. It is tab number 63.
So this case involves two respondents, Kathy Benton, who was a candidate for a city council seat, and her sister Cassandra Russell. Complainants are Takita Campbell and Sanja Eason, who was also a candidate for that same race. The complainant, Ms. Eason, alleges that candidate Benton alleges that the candidate Benton filled out absentee ballots for voters, and also that she took those ballots and mailed them or took them away from those locations where she filled out those ballots for individuals. So Takita Campbell stated on October 6, 2021, Kathy Benton, a candidate for the city council seat in Ward 2, came to her house, had her sign the oath envelope on her absentee ballot, filled out her ballot, and told her she would mail it for her. Mrs. Campbell filled out an affidavit alleging that to Supervisor Kerry Alligood, who's the Toombs County election supervisor. Another citizen and voter, Kathy Benton. Actually, that's another citizen, Mobley Conway, alleges that Mrs. Benton came to her residence, had her sign something, took the documents that she had her sign and mailed them. Later on, when asked, did she vote? She indicated that she did not. So ultimately, the investigator spoke with Mrs. Benton, and she indicated that there were two people she assisted with completing their ballots. She mentioned an individual by the name of, that she knew as Mel, that we identified as Mrs. Conway. And she also mentioned Takeda Campbell. So ultimately, she denied filling out the ballot herself. She did indicate that she filled out her driver's license information because she asked her to. And she also took the ballot and gave it to her sister, Cassandra Russell. And she also admitted to this in a statement she submitted to us. The investigators later spoke with Cassandra Russell, and she did admit that her sister submitted 5 or 6 ballots to her in which she mailed off. So ultimately, we determined that Kathy Benton, as the candidate, violated OCGA 21-2-385B, procedure for voting by absentee ballot, when she, as a candidate whose name was on the ballot for the November 2nd, 2021 general election for the city of Lyons, offered her assistance and did assist electors Daugherty Knight and Almami Conway, which is her real name, but known as Mel, with preparing their absentee ballots. Neither of these individuals are related to Knight or Conway. And also, she did not sign the oath envelope as a person rendering assistance, which obviously she was not allowed to because she was a candidate. Also, her sister and her are believed to have violated, and there is evidence to suggest that they violated OCGA 21-2-385A, procedure for voting by absentee ballot, when they took possession of Daugherty Knight's absentee ballot to give to her sister, Cassandra Russell, so it could be delivered to the U.S. Post Office to be mailed to the Toombs County Board of Elections. Neither Kathy Benton nor Cassandra Russell met the relationship requirements to assist Daugherty Knight. Now, there was other allegations that we were unable to prove, but there's possibly other voters that were assisted in some way. To the extent we don't know, but those are the specific individuals that we were able to prove or have evidence to show that she assisted illegally, and then also taking those ballots and submitting them, another name known as ballot harvesting.
Is it likely there were many other people?
What's that?
Is it likely that there were other people?
Yes.
Okay.
Yes.
All right.
And the sister did admit that it was 5 or 6 ballots. So there's at least 5
6
other
more
people that the ballots were taken. And then the supervisor also said that she was contacted and she specifically talked to the candidates and told them what type of conduct was allowed per the law, that they could not assist others as it relates to that because of their candidacy status.
Okay. Is Miss Kathy Benton or Cassandra Russell here? No. Seems to be a clear and flagrant violation here. Any questions from the board? Chair will entertain a motion.
I move we refer this to the Attorney General's office.
Motion to refer this to the AG. Is there a second?
Second.
We have a motion second from Member Johnston. Any discussion? Any no discussion? All those in favor of sending this to the Attorney General signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. Case number SCB 2021-165 will be referred to the Attorney General. I'm sorry.
Can you repeat the number? I have 168.
Yeah. Hang on a minute. I think I got that wrong. 2021-168.
168.
Sorry. The next item on the agenda is SCB 2021-163, Daugherty County tabulation. It's tab number 65.
Mr. Chairman,
Yes.
as I was involved in reporting this, I am going to recuse myself from this case.
You'll force me to vote, aren't you? Okay. Member Gazal has recused herself from this case. Please proceed.
The complainant, Bobby Fuse, reported that he received a photo of what looked like tabulation results. The picture was received before the polls closed on November 2nd, 2021 election day. The poll manager, Debbie Parker, improperly posted tabulated results for the advance voting period of the November 2nd, 2021 general election. The results were posted on October 29th, 2021. She advised she normally works election day and just assumed this was a proper procedure. So she just made a copy and posted it on the door. It was a mistake on her end. There's evidence to suggest that Daugherty County Board of Elections and Registration, the election supervisor and poll manager violated OCGA 21-420A for procedure for counting and tabulation of ballots.
I have something that was sent to me by Ms. Parker. She was not able to attend today, so I asked if she wanted to write a statement and send it in for this board to hear. And she forwarded this to me. Good afternoon. My name is Debbie Parker, and I received a letter from the State Election Board dated June 30th. RE SEB 2021-163. I'm listed as a respondent on the election case on the agenda for the election board meeting to be held on July 29th, 2025 at 9 a.m. The meeting will take place at the Georgia State Capitol Room 341. I will not be able to attend this meeting. Thank you. And then she sent this follow-up. Good afternoon. This is what I remember to the best of my knowledge. I, Debbie Parker, was an early voting manager and also a precinct manager at the same time. I began early voting manager before COVID, but I was a poll worker with my dad. Then he passed the precinct manager position on to me. On the day of the incident, I completed my paperwork at the end of the election process and mistakenly had a poll worker post the results as I would for election day, not knowing that you're not supposed to post it. The poll worker, who is now deceased, took the results, placed it on his leg, and took a photo of the results and posted them. An investigation with a representative from the Secretary of State came to the Albany Elections Office to meet with myself, Supervisor Ginger Nicholson, and Assistant Supervisor Kamika Johnson to record my statement. I no longer work as early voting manager. I hope this statement helps you. So if anybody would like to see this, that's what she provided me for her statement. She was apologized for not being able to make it here today. Any questions from the board?
Is there,
Yes, ma'am.
is there anyone?
Yep.
Good afternoon. I am Ginger Nickerson. I am Supervisor Ginger Nickerson. We're here also, and here's the county attorney, Alex Shally.
Okay. Well, do you have some comments you'd like to make?
Good afternoon, members of the board. My apologies for walking in late. I made the mistake of thinking that we could grab a lunch break too. And
did you identify yourself, please, for the court reporter?
Yes, my name is Alex Shally. I serve as Daugherty County attorney. And of course, we're here. I'm here on behalf of the respondents in this case. And I wasn't here to hear the investigator's report, but it's my understanding that we have been investigated in the connection of a possible violation of 21-2-420, and which centers around the improper posting of tabulated early voting results.
Why don't you let me let you read her statement real quick, Ms. Parker?
Yeah, that's fine, Mr. Chairman.
Did you hear me read this out?
I didn't hear the statement.
Yeah, you might want to read this real quick so that you know what she said before you start
Okay.
speaking on her behalf. Yes. Just the top part right there is.
Thank you, Mr. Chair.
Does that help you?
It does. It confirms that, we don't dispute the findings, we don't dispute the findings of the investigation. Daugherty County, we acknowledge that, there may have been a potential violation by virtue of our poll workers, posting of the early voting results. And I would also note that the investigator's conclusion also indicated that the posting of those tabulations was inadvertent and was done without the intent to break the law. If I could just give you a little bit of context, as the statement noted, Ms. Parker, who was the poll worker at issue, she had experience as a poll manager on election night. And during the November 2021 municipal election, that marked her first time managing early voting. And so she was under the mistaken belief that she was to post the results as she would on election night. Now, no one from the elections office, either at the staff level or the board level, instructed her to do so. And she did so on her own misunderstanding of what her obligations were. And while the Democratic official who reported the error, who I believe was from nearby Sumter County, reported a complaint, none of the candidates on the ballot nor did any of the voters ever issue a complaint. Since then, Ms. Parker, as well as all the poll managers, have received updated training and instruction as to their posting and tabulation obligations. And a similar incident has not happened since. And in fact, in Ms. Nickerson's 23 years with the election office, that's the first and only time any such occurrence has ever occurred. And so given the isolated and inadvertent nature of the incident, as well as the corrective actions that the county has taken to ensure it doesn't happen again, we would respectfully ask that the board decline referring the matter to the Attorney General's office. But Ms. Nickerson and I are available for any other questions the board has. But outside of that, we very much thank you for your time and consideration today.
Are there any questions from the board?
Mr. Chair.
Yes.
To the attorney or Ms. Nickerson, did the county provide training for how to handle the Dominion equipment, the tabulators at the end of early voting?
We did provide training in terms of the equipment. We did not discuss the tapes. Previously, Ms. Parker had worked at the advanced voting location. She just had never been the manager of the location. And customarily, we always utilize for our advanced voting location. Thankfully, we're able to use our election day workers because we're grateful for that because they're more familiar with the equipment that we, since as was stated, we do make sure that we train them to let them know that you do not pull the tapes and you do not post tapes because this is prior to, and the law states that we would have to notify in advance if we were going to do early tabulation, and there's a time frame that we can do that.
Can you explain what is the procedure for the scanners at the early voting sites on the last day of early voting?
I know we don't end the election because you can't close it out. So we don't tabulate until at 7 o'clock on that night because that equipment is brought up to our office for closeout. they are provided instructions. We do have laminated instructions on how to use the equipment in advance, just like we do on election day. And it does not have where you close out the election as you would on election night.
Ms. Nickerson, we've heard cases where an inadvertent punch of the button closes the poll rather than just shutting down the machine. We've had cases before that we've heard here at the state election board. But the worker immediately knows they've done something that they've caused something to happen that they don't mean to happen. And we've heard cases where those tabulator tapes are put in a drawer or locked or put away from view. I find it curious that this tape was, one, photographed, and two, posted. So my other question is, how long was the tape posted on the door?
To our knowledge, not long, because it was gone when we it was gone when we went to look for it. But I cannot honestly give you a time frame. Being honest, I do not know. I do not know.
So Ms. Gazelle, I know you've recused yourself, and that means that you will not vote on this case. You're welcome to, if you have information to fill in any blanks to share with the group.
So I was made aware of this by the complainant, and I immediately reported it to the Secretary of State's office as a violation, which is why I'm don't want to take part in the vote. That is all. The investigation report reflects my knowledge of it, which is that Mr. Fuse, who is in a different county, received this photograph sometime overnight. He saw it in the morning and immediately alerted me because he knew there was something wrong. As an activist, he's very involved. He does a lot of nonpartisan work, and was concerned and reported it up, and that's how it got reported immediately. He did not share with me where he got the photograph from.
The photo wasn't a picture of a window, correct?
No, it was to the best of my knowledge, it was a picture of the receipt on somebody's leg. They put it on their pants leg and took a photo of it.
So we have a situation where it wasn't just posted on the window as you stated, where someone can take a picture of it publicly and share it. But this was inside job, basically, where someone took a picture of this receipt on their leg and then sent it out to various people, ending up in the hands of someone who's not in the county. Are you aware of that? From my understanding, they took the tape from the door. From my understanding, that's why the tape was gone. We didn't take the tape down. So have you seen the picture? No. Okay. No. So I know the tape was removed. So I don't know. When we went to retrieve the tape, I know it was removed. Okay, so you weren't aware that it was taken inside the building and then, or somewhere else and sent out. Okay. I think that's the part that's the most concerning. And even, I'm sure it is for you as well, that this has gone beyond the window. And I feel like beyond, I know that you've done all you could to mitigate this, and it's not on not your fault, but I do think this deserves further looking into, because again, a lot of the information that was just provided, you weren't even aware of. So the factor of who took the picture, where they send it, how many people had it, I mean, that's a bit concerning.
Well,
If
the picture that was sent was a picture of the results on somebody's pant leg, right?
The person who sent it to Bobby Fuse wanted to be anonymous, but we did speak to them and they weren't the person, they got the picture sent to them. That person was interviewed and said, he received the picture of the tabulation results the night before, and he sent it to Bobby Fuse. And then he felt that they should not have been posted. They contacted the Secretary of State. This person who wanted to remain anonymous said that he spoke with the individual who sent him the picture of the results and told him it wasn't allowed. He said that he didn't feel that it was for a nefarious reason or to back a certain campaign, just that it was a mistake. But he didn't say where he got the photo from, and he wanted to remain anonymous as well.
And so
So Miss Parker admitted that she posted them on the door and somebody took them down. We don't know who took them down and then sent the picture on. So that's the.
But we don't know who that is.
We don't know who that is. Yeah,
but it's the violation. I'm sorry, I know this, I've recused here, so this is uncomfortable, but the violation is the tabulation. Taking the picture and spreading it on, is that there's no violation in that? So.
Well, but we don't know, we don't know who did that.
Right.
I mean, the violation here is just posting of it on the door.
That's
the violation. We don't know who did these.
Yeah. Right.
Yeah.
They post them on the outside of the door, correct?
Right.
So
And that's the violation we're talking about, is the posting of it on the door. Not that it was sent someplace, which is another violation, but we have no idea who did that.
And Mr. Chairman, if I may,
Yes.
we have not had the opportunity to review the picture. I think there's information that the board is privy to that we haven't had a chance to vet and fully investigate. To the extent we could with the information we had, we certainly tried to make every measure to remediate and take corrective action. But the information that there may have been a photograph on someone's leg and it may have been disseminated to someone else, that's not information we've been privy to until today. But we'll certainly continue to do everything we can on our end to mitigate the effects of that error.
The case that we're here to talk about today is just the actual posting of it on the door. That's the other one may be another case if they ever could find out who sent the picture around. But the case we're here to talk about today is just the posting of it on the door. And Ms. Parker has admitted to that, and we know what happened. And there's obviously a lack of training on her part is the reason it occurred. So I think we have to deal with that one particular issue. Is there the chair would entertain a motion on this?
I moved that we issue a letter of reprimand for this particular situation. As we stated, we don't know much about the other, and but you have took the steps to mitigate this. So that's the motion I'd like to make.
You have a motion to issue a letter of reprimand. Is there a second?
Second.
With motion and second to issue a letter of reprimand. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Aye. Motion carries 3-0.
Thank you.
Thank you. Have safe travels back to Daugherty County.
Thank you. Thank you, members of the board.
I encourage you to investigate the picture being sent around too.
We certainly will. Thank you.
Discussion agenda is SEB 2021-119 Calhoun County Voter Registration Challenge. It is tab number 67 in your binder.
This case is about improperly challenging. So they had Betty Murdoch who challenged 75 voters. The investigation revealed that Betty, who made the challenge, did not provide Brooke Deal, the Board of Registrars, with a challenge in writing specifying distinctly the grounds of the challenge as required by statute. When she was interviewed, she advised that she just drove around neighborhoods and found places that looked uninhabitable. Those were the ones that she selected to challenge. The investigation also revealed that Brooke Deal did not, within the letter of notice mailed to electors, serve upon the electors whose qualifications were being challenged a copy of that challenge. Also, Chief Registrar Sarah Causey and another member of the Calhoun County Board of Registrars revealed that they knew that Brandon Wins likely did still reside in Calhoun County. They were made aware by a board member that the challenged elector was attending job training out of town and likely still did reside in Calhoun County. Despite that information and the fact that Betty Murdoch didn't show up for the scheduled hearing, the board still voted to remove Wins and other names from the electors list of electors. There is sufficient evidence to suggest that Brooke Deal, Sarah Causey, and the Calhoun County Board of Registrars violated OCGA 212229, the challenge of applicants for registration by other electors.
The respondents in this case are Sarah Causey, Chief Register, Brooke Deal, Calhoun County Deputy Register, and the Calhoun County Board of Registers. Is anybody here outstanding? Would y'all push your buttons there and yes.
Did I get the right button? Okay.
You don't have to stand up if you don't want to. It's
Just felt it was more respectful. Sorry.
all right.
Old fashioned. I'm Sarah Causey, and at the time I was the chief registrar for Calhoun County. Calhoun County was one of the few counties that were still using the old model where we had a separate board of registrars. We did not have a board of elections. We did not have a combined board. So it was just us, and the board consisted of 5 members, myself and 4 other people who were all well past their prime age-wise, but y'all won't hold that against us, I'm sure. And the county had 1 employee in the registrar department, and that was Brooke Deal, who was the deputy register. I had the title of chief register. I was not an employee of the county nor present in the county office all of the time. Sounds like I'm making excuses, but I just want you to understand. Our understanding, I couldn't really hear everything she read. Sorry, but part of it didn't sound quite what the information that we had showed. But here is what happened as I know it to have happened. Brooke was hired in 2019 as the deputy registrar. She missed training the first year because her daughter was in the hospital here in Atlanta in critical condition. And I went in her place to the training. No other board members went to training. Some of them did the online training thing, but at any rate, the training did not really address in detail how to handle challenges and all. And none of us are lawyers or even knowledgeable about the law. Never been in trouble with the law before. But there was a city election coming up, and there was a citizens group in Arlington, which is one of the 4 towns within Calhoun County. Now, Calhoun County is very, very small county. And the citizens group in Arlington, Betty Murdoch, who you heard mentioned, was one of the leaders of that group. And they came up with a list of names that they said did not reside in Calhoun County, or certainly in Arlington. This was a city election. We also had, because this was our year to do a normal, check of the voter rolls to see any changes, people had moved away or whatever. Our job was to actually Brooke's job, to consult with the various cities who all do their own elections. We're not involved in the elections, and neither was the election supervisor. And she was not named in this, and unfortunately, she is extremely ill and has not been at work in months. But at any rate, we had these lists from those people, and we had the list from this citizens group. We were unsure how to go forward because what we were given was a list of names with a sentence across the top saying, these individuals no longer reside, within the city of Arlington or within Calhoun County. So we tried to figure out what we were supposed to do. We talked to, and can give you more details because as the employee, she was the one handling a lot of the calling or, sending out the letters. The board composed the letters and told her when to send them out. But we sent the letters to all of the people we were given names. Meanwhile, this citizens group filed a lawsuit against the city of Arlington, and they named the Board of Registrars and Brooke and myself as representatives of the Board of Registrars in that lawsuit, even though we had no responsibility for the city election at all. We did have a responsibility to, maintain the voter rolls, of course, and to make sure they were as accurate as they could be. So we talked to the county lawyer. You notice he's not here today because the county lawyer, because I called him after we got the letter from y'all and asked him. I didn't get him. I asked him to return my call. We wanted advice as to, what to do, other than come here and try to explain what happened. And I called the city manager to get the lawyer's phone number. I had moved out of the county in 2023 because of my husband's health concerns, and we were 45 miles from the nearest cardiologist, and we moved to Daugherty County, Albany, to be closer to good medical care. That's one of the drawbacks of living in a little country town. There are a lot of pluses to it. And so I was no longer on the board. All of the other board members had resigned in 2024 because the county had decided to do away with the model that we had with a board of registrars that were appointed, selected by the grand jury and appointed by the Superior Court judge. And they had gone to a different model, which Brooke can maybe tell you more about. I haven't been involved since 2023. But she's not in Calhoun County anymore either. So all of the board members that were there at the time are no longer there. She's no longer there. I'm no longer there. But here's what happened. We tried to get advice from the lawyer. We tried to get advice from employees at the state election officials. And Brooke has emails and things from various ones. And in the midst of this, here's this hearing about the lawsuit in which we are named as respondents. And Judge Bishop, who handled that, later, told Brooke, I was not present for this, but Brooke and the clerk of the court, that we should continue with the efforts to determine whether these people did still live in the county or not. So we had this pressure that we've got a Superior Court judge saying move forward with this. And he later supplied us with a thing in writing, supplied the office, the registrar's office with it. So we didn't have like individual letters up with each person. We just had a list of names and the statement that they no longer resided within the county. And she stated that they were challenging these voters because they no longer live within the county. And so we sent out letters.
Let me ask you a question real quick.
Sure.
Sorry to interrupt. So you received a list of voters and you said just a name only and that somebody claimed they were no longer lived in the county?
And the statement that they were this group, citizens group that Betty Murdoch was the leader of, was challenging them.
Was there any backup documentation provided with that or just the list?
No, the only other thing we had was the Superior Court judge saying, move forward with determining whether these people.
Okay, but the person who submitted the list gave you no backup documentation at all, just a list of names.
No, the only other thing we had were the lists, which overlapped her list from the clerks, within the cities that handled the city elections. They send us a list of people that they believe have moved out of the county based on the fact that they no longer are getting utilities at the place where they were getting utilities, whatever.
Who provided you with that list?
the city clerks.
Okay, but the individual making the challenge did not provide you with any documentation at all.
No.
Okay, that's all. That was my question.
Okay, I have just a little bit more. What? So we sent the letters out. We know now that apparently we were wrong, not to have something more to send out. But I'm sorry, but we felt very pressured by the whole fact of the Superior Court judge telling us something. The people in Atlanta told us one thing, and then the next day sent something back and told us something different. At any rate, I'm saying I don't think we did follow the letter of the law, but I want you to understand that we had no intention of, doing something wrong. And the only reason we didn't include that, as I read the thing now, it doesn't say that they have to send documentation. It just says they have to say why they're being challenged. And I may be wrong, but I'm just telling you, I'm not a lawyer, but that's what I see. And we didn't want to send out the whole list because we thought it might be inappropriate or possibly even illegal for us to send out the names of everyone who was being challenged to everyone who was being challenged, because each case was an individual case that needed to be dealt with on an individual basis. Now, to speak to Brandon in particular, Brandon was personally known by several board members, including his first grade teacher was one of the board members. And he was best friends with her grandson. And she stated that she knew for a fact he had been living in Atlanta. Now, we were aware, I certainly was aware, that someone could move back to Arlington at any time, obviously. So Brandon did not come to the date. He did not come for the hearing. And so the board member that knew him personally called him on the cell phone, and he told her that he was in Americas, that there had been a death in the family and he was in Americas. And he said, yeah, he was in Atlanta, but he was up there for training or whatever and whatever. So we said, well, just send us something, and then you can send us, you can email, you can fax it, you can send us whatever. Just send us something that shows you still reside within, Calhoun County. And so he said he would, but he didn't. And so eventually, when he didn't respond, in fact, he sent an email to someone stating that he was not going to give the board anything they asked for. I don't know why. I think I think he got mad, but eventually, though, everybody that responded to us in any way and had any way to show us that they lived in Calhoun County were not removed from voting. I mean, we were not trying to get people removed, but we had been told by the Superior Court judge to deal with this. And we weren't getting any advice from the people we tried to get. So I'm saying we made mistakes, and I'm truly sorry. And what the county got, the only things that have been done to remediate this is that the county changed the whole model they use for we no longer have an elections supervisor. It's combined with the deputy registrar. I'm not sure what the lady's title is anymore. I don't know how that works, but none of the people involved are within the county or anything. That doesn't negate whether we did something wrong or not. I'm not saying it did. I'm just saying we just did the best we could at the time with the knowledge that we had at the time. Thank you for your time.
Ms. Steele, did you want to speak?
Thank you, covered it.
Did you tell Mr. Wims that you didn't get paid enough to deal with people like him?
Hey, I had the.
Yeah, she's on.
I have the whole conversation here if y'all want to see it, because I knew who I was dealing with and I wrote it down back then in 2021.
So you said no, okay. All right.
No, sir, I did not say
All
that.
right. I just it upsets me that somebody can turn in a list of 75 people and just say these people shouldn't be on the list, and then the county officials have to respond to that without any evidence or anything. And I mean, that could go on for on and on and on forever, you know.
And we didn't know how to handle it or what
Yeah.
to do or where to go. We'd never done anything like that before.
Yeah, it concerns me that those kinds of things are happening these days.
Yes, sir.
Mr. Chairman.
Yes, Member Gazal.
So I'm very conflicted here because I think that the county really failed you too. Because the county has to support its people. And if the county the county chose the structure of having an independent board of registrars and they did not provide you the support that you needed. And I am ashamed on behalf of the county that they did not send an attorney up here to represent the interests of the county, since neither of you live there anymore.
I still live there. I just don't work there.
Right.
Yeah.
But they did not see fit to represent the interests of the county.
No, in fact, when I called the city manager to get the phone number for the lawyer, she told me that he could not represent us because he was the county's lawyer and he would have to represent the county. But since the county wasn't named as a respondent, I mean, we thought we were the county. We were the appointed people, you know, for the county. But that's what we were told, that he could not represent us.
And this is where I'm conflicted, because at the same time, I share the same concerns of the chairman, that under state law, the burden of proof rests with the challenger, not with the voters. And if a challenger cannot prove that the voters are no longer qualified voters, they are the ones who have to prove that. And if they cannot prove that, then voters need to remain. But more to the point, and this is not something I would expect you all to know, but I do expect that counties and attorneys would know this. This is actually controlled by federal law. Federal law, the NVRA, National Voter Registration Act, is the controlling statute here, and it preempts state law in this. And I have a statement of interest that was issued on July 8th, 2025. So by this current Department of Justice, that they filed in a case in Illinois concerning states' obligations under the NVRA. And I'm going to read it into the record. Section 8D establishes specific requirements for the removal of names from voting rolls. Section 8D1 of the NVRA provides that a state shall not remove the name of a registrant from the official list of eligible voters in elections for federal office, which in Georgia is the voter list. We do not have separate federal and state lists, on the ground that the registrant has changed residence unless one of two circumstances has occurred. And I'm removing internal citations because it's just confusing. The first is when, quote, the registrant confirms in writing that the registrant has changed residence to a place outside the registrar's jurisdiction in which the registrant is registered. Now that's confusing. That means unless the voter has told you in writing, either through deregistering or a copy of their registration in another jurisdiction, that is when that circumstance is met. The second is when the registrant has failed to respond to a notice and has not voted or appeared to vote in an election during the period beginning on the date of the notice and ending on the day after the date of the second general election. So if that is that inactive cycle where they go, you have to wait 2 federal election cycles. Those are the only circumstances in which you can, any jurisdiction can remove a voter from the voter list if they've moved. Now, there are other circumstances. If they're no longer eligible for reason of because they have passed, if they have been rendered ineligible through a court order, or if they are if they have been convicted of a felony, those are reasons that they can be removed immediately. No, I mean, if they move out of state, you have to go through these. Only under these circumstances can you remove them from the list. You either have to have it from them in writing, or you have to go through the two federal election cycle. So even when our challenge laws looks like you can put them in challenge status, but you can't remove them from the rolls. And that's something that it really, and this is the current Department of Justice quoting from their filing from 3 weeks ago.
Give me a quick list again of the people that you asked for assistance with this.
One of our liaisons was Dennis Carbone, which he's gone.
Yep.
Chris Harvey, which he's gone.
What were their positions?
Elections director.
He worked for some.
Chris Harvey was the elections director.
Elections director.
Well, I couldn't remember what his position was back because it was back 21.
Right, so you asked him. Who else did you ask?
Our county attorney.
And your county attorney, and they didn't help you either.
No, sir.
And the Superior Court judge told you to move forward with this.
Yes, sir.
So you were told by the Superior Court judge to move forward. You asked for assistance. They didn't help you.
Yes.
So you moved forward with it, which resulted in 72 people of 75 being removed from the rolls inappropriately.
75 were not removed. They were
72 of the 75.
72 removed. I don't think so. Unless that was the list from the judge, and if it was, then it may have been.
Yeah, there were 72 of the 75 that were removed improperly because you weren't helped when you asked for help and
Let me add that we did ride around, me and 3 of the board members did ride around Arlington and to the addresses to see if the people did live in the homes. And we did run into a few, and they did tell us they didn't live in the county. So we did do that as well.
And if the letters were returned undeliverable, we then gave them to the local police department, the county sheriffs, or which were they, whatever, law enforcement, and they then attempted, and I think that's in the regulations we were told. And they attempted to deliver the letters.
yeah, it seems to me it shouldn't have gotten that far to begin with since the original list was improper. So yeah.
Mr. Chair.
Yes.
So the problem with the voter rolls, did you think to perhaps flag or mark a status reason on the voter rolls for what you found out when you?
We thought we had after the fact. Now,
Right.
that we talk about that after the fact.
Right. So the MVRA speaks about active voter list and an inactive voter list. And they also speak of the inactive voter list is for eligible voters that just simply are infrequent voters or non-voters, basically. And it implies that everybody that's on the inactive voter list is eligible to vote. But we all know that there are many, many people on the voter list who are not eligible to vote. They're no longer qualified to vote, and which is creating a huge problem with our voter rolls, not only in this state, but in many counties and in the whole country. So I appreciate my colleagues' earnest speaking about not removing people from the rolls for 2 elections, but what's missing here is the word eligible. And so if you're going to have an inactive voter list, you might as well have an ineligible inactive voter list for voters that really have moved to another jurisdiction, another state, or registered to vote somewhere else, or actually voted somewhere else. Not your problem, but it's our problem, or the legislature's problem, or Congress' problem. And it is creating a great deal of difficulty with managing voter lists and providing a list of who is eligible to vote in each election. And the issue with inactive is that if they're on the inactive list and they call the election office and ask for an absentee ballot, they get one, but they may be unqualified as a voter in that jurisdiction. are ineligible to vote. But we're having difficulty distinguishing the difference. So I sympathize with the dilemma that you were put in to deal with these challenges without documentation.
Any further comments from the board? Chair will entertain a motion.
I just want to be on record that I personally believe that this is a county issue. I stand with Member Gazal that the county should be present, backing you and supporting you in this. And I'm sorry that you have to deal with this on your own.
Chair will entertain a motion at this time.
Yeah, I make a motion that we issue a letter of reprimand, considering that the county is not here. It would be on them to take the responsibility of this. And I do think that you've done all you possibly could to try to rectify it, and being told by the Supreme Court that you should move forward, you're kind of put in a situation that was difficult.
Would you
Sorry. Did I make a motion?
You did make a motion. I just want to question whether you would consider a letter of instruction versus a letter of reprimand, given that they seem to have gone the extra step even without any assistance from the county for these two individuals.
Okay.
So.
Okay, I can do a letter of instruction.
Would you like to restate your motion?
Yeah, so I will amend my motion and make a new motion, which is to issue a letter of instruction.
Is there a second?
Second.
We have a motion and a second to issue a letter of instruction. Is there any discussion?
Mr. Chair, I have great difficulty with these two workers who were only trying to do their job and asked to respond to this challenge list, and then told by the Superior Court to violate the law. Now, I have a real problem with that, and I just don't think that that I can support any kind of motion, a letter of instruction or reprimand for these two ladies because they were told by the Superior Court to violate the law. And there's something wrong with that we're holding them accountable for what a court told them to do.
I absolutely agree with you on this. I agree. My problem is that there are 72 voters removed, and so there's a clear violation of something. And I have all the sympathy in the world for you, and that's the reason I thought a letter of instruction just saying.
I want to dismiss it, but I mean, at the end of it all, I felt like instruction would at least provide them with steps going forward.
In good conscience, I cannot support anything but dismissal in this case. Even though there's something, I have a concern about simply removing 72 voters. I don't know how many of those were actually ineligible voters, or what the number is on that. But they can certainly be replaced on the rolls. And that happens quite often when a mistake or inadvertent removal occurs. So it's not that it's such a horrible action that any correction cannot be made or was not made. I'm not sure what the corrective action was. Perhaps you could share that with me. But I have a real issue with the court telling someone to violate the law.
Any further?
If I could get a clarification, did the court order you to remove these specific names, or what exactly was the direction from the Superior Court?
I was not present when the judge said it, but we do have a thing sent later, and what he said is my understanding.
Have a microphone, please.
Oh, I'm sorry. I was not present at the lawsuit where that was done, but we did get later in writing. The first thing I asked the clerk of the court when she informed me was, do we have something in writing that tells us to do that? And she said it will be in the the court record, you know, but it will take several weeks to get that, where we were just by this point only a week out from an election. But it was all the list. But at any rate, the thing told us to move forward with determining whether or not.
Okay, so they told you to determine whether the challenge list was valid. They didn't specifically say to
determine whether or not these were.
Excuse me, the court reporter has a real hard time trying to get everybody's language down. So if we could just speak one at a time, please.
She has in here the thing from the judge. I don't remember the exact words, but as I remember it.
And if I can also clarify that within 10 days of an election is the blackout period. So there's no way for somebody to re-register in time to vote in that election.
Yeah, it was a city election. I don't know. What we were told was ultimately, and I don't know if Brooke can remember who told us this, was we said it is too soon. We can't even, when we were told to move forward by the Superior Court judge. Then we were told by the state, the Superior Court judge doesn't have a right to tell you that. And so then we were told by the state to move forward with sending out the letters. And then after we mailed the first round of letters, they informed us that we needed to cease and desist and not hold the hearings. And
one at a time, please.
So, Mr. Chair, if I may, I'm willing to withdraw my motion.
It is your right to withdraw and re-amend your motion if you'd like.
And I don't mind re-amending it to dismiss, to make a motion to dismiss this case.
We have a motion to dismiss this case. Is there a second?
Second.
We have a motion to dismiss this case. And there's a second. Is there any further discussion? Having no further discussion, all those in favor of dismissing this case signify by saying aye.
Aye.
I'm sorry.
Aye.
Aye.
Any opposition?
Nay.
Nay. Motion carries 2-1. Thank you, ladies. Have a nice trip back south.
It's a 3-hour trip and we're happy to be heading home, and thank you so much for your consideration and understanding.
Thank you. Thank you.
I do feel like
we're down to our last two cases. The next case on the agenda is SCB 2021-116 Toombs County Special Election Runoff. It's tab number 68. Please proceed.
So the Secretary of State's office received a complaint regarding Toombs County, indicating they had a problem with their poll pads not encoding voter access cards on July 13th, 2021. Also, that they did not have enough emergency ballots on hand. Our investigator actually went to that location and spoke with the representatives there from Toombs County Board of Elections, specifically Carrie Alligood, who's the election supervisor. Ultimately, they did fix the problem with the poll pad. They were fixed between 7:30 a.m. and 8:58 a.m. at the 5 precincts. And when the investigator went there, he went to each location and spoke with the managers on site. None of them apparently were familiar with emergency ballots, and they did not have sufficient emergency ballots on hand. He further spoke with Mrs. Alligood, who admitted when he inquired about training that she did not conduct training due to staffing shortages. She said she had many elderly individuals on her staff. She lost a lot of poll workers because of COVID, and it made it very difficult for her to run the election. So ultimately, We found evidence to indicate that Toombs County Board of Elections and Registrations and Carrie Alligood, who's election supervisor there, there was evidence to suggest that they violated OCGA 21-299 regarding instruction of poll officers and workers in election procedures for not conducting training and also for not having our SCB Rule 183-1-12-.11 sub 2 sub C, conducting elections when they did not have the sufficient number of emergency ballots. There's 16,558 Toombs County registered voters. So there should have been 1,655 or 10% available emergency ballots at the polling precincts. Man, there's flies in here.
Okay.
You finished?
Yes.
Senator Blake Tillery wants to respond for the Toombs County Board of Elections and Casey Alligood. Are either one of them here today? Toombs County?
Mr. Chairman, we're online.
Senator Tillery.
Just Blake. We're online.
Oh. Tiller, can you hear us?
Yes, sir. Just Blake, Mr. Chairman. I'm county attorney for Toombs County and heard the last proceeding. We do believe it's important to show up for these things, even when the outcome didn't change anything in an election. Thank y'all for allowing us the opportunity to respond. I want to carry you back a little bit in history. This was the first election to occur after the new elections laws of Senate Bill 202. This election occurred July the 13th. The law changed on July the 1st of 2021. So in this, what actually happened here was a runoff for a special election for a state house seat. In the runoff, the poll pads, there was a change in how the poll pads were updated from July's the primary to the runoff after July 1st on a technical issue at the Secretary of State's office. There were trainings conducted. So I want to back up on that a little bit. Prior to, and there were 2 trainings prior to the election in July. There was not a training after the law changed July 1st and before the election on July 13th. But I present to the board, especially with the 4th of July in between, it would have been almost impossible to pull that off while also conducting an election. The ballot, the proposals that were said that we violated the rules. There were emergency ballots in the precincts. The poll workers knew them as provisional. We've changed the training to make sure that they understand that provisional and emergency ballots are the same thing. We've also updated the training as it relates to how provisional ballots should be conducted. For the purpose of assuaging any concerns that the State Elections Board may have, please know that we also filed a hearing to have the polls left open for the requisite number of minutes that they were not open due to the poll pad failure. And that request was denied by the Superior Court. As you know, the rules changed with Senate Bill 202. You're not allowed to go to just any judge any more. You have to go to a Superior Court judge. The Superior Court judge, in great fashion, expeditiously held a hearing on the matter. And in the hearing concluded that there was no evidence that anyone was not allowed to vote. The 3 provisional ballots that were handed out, of those, one person actually handed theirs back, so they wanted to come vote back later, and everyone else still remained in line. So it did not meet the new Senate Bill 202 statutory requirements for even leaving the polls open. That being said, we do admit that we should have had more provisional ballots on hand. We're cautious in the county and do not like to have a lot of ballots lying around, so we only send 5 to each precinct, keep the others bundled at the central office so that if there is an issue, those can be handed out. And I hope that explains why the findings were made and also the steps we've taken subsequently to address this in training.
Senator Tiller, do you know how many people voted in that election?
I don't know the total number. I could have pulled that for you, Mr. Chairman, but I know who the winner was, but that's it.
Does the county know how many people were impacted by the late opening of the polls?
But the late opening of the polls was less than 100. But we also know that there was no evidence that anyone did not vote. And that's what the Superior Court judge found.
Yeah, the judge denied it because he claimed that no one complained about being, delayed or disenfranchised. So that's why he denied the request apparently to extend the voting hours.
Okay.
And Mr. Chairman, we have to agree with that decision based on the rules in Senate Bill 202, OCGA 21-2-403B. The judge likely got it right.
Any other questions from the board? So, just microphone, please.
I am fairly certain that the 10% emergency ballot predates SB 202. But I'm not going to put money on it because I don't have that right in front of me. But it is as a technical violation, and it is something that certainly is required. I would be supportive of simply a letter of instruction in this case. This is a requirement moving forward. I trust that the remedial training has taken place, but as a technical violation, I think it's worthy of a.
Dr. Johnson, any comments?
No comments.
The chair will entertain a motion at this time.
I would move that we issue a letter of instruction to the county reminding them of the requirement of a 10% emergency ballot.
We have motion to issue a letter of instruction on SCB 2021-116. Is there a second?
Second.
We have motion and second. Any further discussion? Hearing no further discussion, all those in favor of issuing a letter of instruction on SCB 2021-116 signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. Letter of instruction will go out. Thank you, Senator Tiller. We appreciate your time today.
Thank you, board. Hope you have a good afternoon.
Thank you. Our last case today, and then we'll have public comments, is SEB 2021-043 Decatur County. Multiple complaints on this one. Please proceed.
Yeah. This is the Decatur County, right? Okay. This is a continued case from last, so it's not multiple. This is the one to what? You talking to me?
Yep.
Okay.
That's okay. I was turning the volume up here.
That was my fault. I was talking to.
Oh, okay. So this was a continued case. The only part that Miss Cooper, so Mary Dunn was already voted on, and then Grace Cooper got up, and that was the one who was alleged that she signed her daughter's oath envelope, and she said she didn't. Said she hadn't voted since 2012. And then made some allegations against the county. Do you remember?
Mm-hmm.
Okay, because I don't think she was coming back, she said. But you had the attorney that was emailed to you guys yesterday, I think, that he had responded. So he got the letter, but they're not a respondent, so he didn't think he'd be allowed to talk. So they didn't come. So just to recap, because I know you weren't here last time. Grace Cooper signed the oath envelope for her daughter, Jasmine Sheffield. When she was asked about it, she said she did not sign, but if she had, it would have been a mistake. Grace sent in her own ballot and it was accepted. She then attempted to vote in person, but was turned away. Jasmine spoke to the investigator briefly, but did not answer if it was her signature or her mother's signature. So at the last meeting, Grace said that none of that happened and she hasn't voted since 2012. Mm-hmm. So the timeline was December 7th, 2020, Decatur County received a mail-in ballot issued to Jasmine Sheffield. The oath envelope was signed by Ms. Cooper. The ballot was rejected and the office issued a new ballot to Ms. Sheffield on December 9th, 2020. They also sent a letter to Ms. Cooper advising her what happened and that it is illegal to sign another person's oath envelope. December 10th, 2020, a mail-in ballot for Ms. Cooper was received and accepted. December 14th, 2020, Ms. Cooper attempted to vote in person and was sent away. Those were all charges that she did not. It said she'd never been in there, that it was a personal vendetta against an employee. So on 7/28/25, the attorney, Bruce Curbo from Decatur County, he emailed me. And his email said the attached refutes the claim of Ms. Cooper and that she had not voted in Decatur County since 2012. Ms. Cooper also made claims of nefarious conduct by unnamed staff of the local elections board and or Carol Hurd, our former election supervisor, and or election office employees. Those allegations were and are without merit. Finally, the communication received from the board subsequent to the first appearance of Ms. Cooper suggested that my clients would not be heard if they attended on July 29th. For that reason, no plans have been made to attend. But in his documents, it was the transcription from the last meeting where he made some comments. Did you all receive that? So you want me to go over all that too? Okay. She was saying how she hadn't voted and it said ballot, absentee ballot accepted 2016, 2018, 2020, 2021. She said that she moved from Georgia, but then she still has property there, but she's still voting according to Calhoun. Okay. That was all. I mean, he sent all of that.
Any questions from the board on this case? Dr. Johnson?
My question is what exactly she was saying. I couldn't make heads or tails of whether she had voted or not voted or lived in Florida or lived in Georgia.
She was saying that, remember, she didn't even go in person, that they lied about the whole thing, that she was never there, but
Right.
they had employees that knew her and they were like, yeah, she did, but.
Any further questions from the board? Chair will entertain a motion.
Yeah, I make a motion that we send this to the Attorney General's office for them to continue investigating this.
We have a motion to send the case number 2021-043 to the Attorney General's office. Is there a second?
To be clear, a second, Mr. Chair, you're talking about allegation number 2.
Yes.
Yes.
We have a motion and a second to send allegation number 2 related to Grace Cooper to the Attorney General's office for further review. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. This will be referred to the Attorney General's office. That concludes our case list for today. We will have public comment now, and then we will adjourn for the day and take this up again tomorrow morning. Let me ask the board, do y'all want to start at 9? Or I guess it's already on the agenda, so we'll start at 9 instead of 9:30.
Yeah.
The public comment today, we have 3 people that have signed up for public comment. Ms. Burkhart, you're number 1 on the list. Ms. Lee's number 2 on the list, and then Marissa Powell is number 3 on the list. And so that will be it. If the 3 of you would prepare your statements, please. And if you would please keep your comments to 2 minutes as we do for all public comments. And our new executive director, who can be a very mean man at times, when 2 minutes is up, he may slightly guide you to finish your comments. Yeah, Ms. Burkett, let them get their stuff out of the way, and then we can and we'll let me just state for people that we have 17 cases tomorrow. We have 2 that will be heard by Hall County first, and then 6 Gwinnett County cases after that, 2 DeKalb County cases, and then 7 Fulton County cases to wrap up the cases for the day, and then we'll finish with the rest of the agenda after that. And so we'll start bright and early with Hall County at 9 a.m. in the morning. Ms. Burkhart, please proceed.
My name is Sandra Burkhart, and I've had the privilege of coming to this room many times. And I want to tell everyone on the board and the new administrator that I greatly appreciate all that you're doing. I'm a woman of prayer, and I'm passionate about truth and justice. And I want to do everything I can to see that our elections are fair. And I appreciate all of those that work in terms of freedom and justice in this country. Thank you for your time.
Thank you, Ms. Burkhart. Ms. Gail Lee, I believe, is next.
Ms. Burkhart, you've just become my favorite public commenter. So let's see if somebody else can beat her on that. So
Probably not.
Ms. Lee, please.
Gail Lee with DeKalb County, in DeKalb County, rather. In 2023, I filed a 4-part complaint with the SCB against the DeKalb County Board of Registrations and Elections for rejecting all challenges to voter registrations I brought before them in 2022. You heard the first 2 parts at your May 14th meeting, and we'll hear the other 2 tomorrow. The first part of the complaint was because 230 challenges were denied on electors whose status was inactive due to MCOA or return mail, and whose status was automatically returned to active merely for applying for an absentee ballot. FCB dismissed that part based on the investigators' misapplication of a provision in OCGA 21-234A, which merely resets an active elector's date of last contact by applying for an absentee ballot. However, OCGA 21-235 sets out 4 scenarios where a person on inactive status can be returned to active, but it makes no provision for absentee ballots. That may be a legislative oversight, which DeKalb currently navigates by changing inactive to active when an absentee ballot is actually returned for voting. The second part of the complaint involved electors who were registered at a residence address, which was clearly non-residential. Despite the address being on its face illegal and ineligible, the DeKalb board denied the challenges because I couldn't prove the person didn't live in DeKalb County. Your investigators found one challenged elector who lived in another county, and you referred that one to the Attorney General. But instruction was not given to the DeKalb board on how to handle ineligible residence addresses, which was the point of filing in the first place. So now, as a recently seated DeKalb board
10
member,
seconds. Must be about 10 more seconds.
okay, so now as a recently seated DeKalb board member myself, I'm requesting the board receive that guidance. Thank you.
Thank you.
Thank you, Ms. Lee. Ms. Powell?
I don't think I will beat the time record, but I am thrilled that we'll go home before traffic.
Okay.
Hi, folks. My name is Marissa Pyle. I'm with All Voting is Local Action. Late last week, news broke of a new conflict with the SCB regarding hiring for the vacant or previously vacant paralegal position. There was coverage that the 3-person majority on this board, over the concerns of the chair and potentially, according to story, without the consent or involvement of the Democratic member, voted to approve the hiring of the wife of the former executive director of this board, raising serious concerns about the transparency and legality of the process, as well as the qualifications and intent behind this decision. I don't think I need to remind anyone of the dozens of legal actions that have been brought against this board for its actions over the past year, which have often contradicted the advice of experts and the board's own legal counsel. This action at best is disappointing. At worst, it is a furtherance of the instability, the lack of transparency, and the partisan actions that this board and voting majority has continued to take. The purpose of that position is to help ensure that records are maintained, which is already a subject of active litigation, in compliance with sunshine laws. Cases are heard in an effective and organized way. Parties to cases have notice of hearings, and much more. It is a role that carries profound implications for voters, counties, and investigations, all of which depend on the actions of the individuals who fill it. We have rules and requirements around the hiring of positions like these for a reason: to maintain trust, and at least publicly, it is not clear that those rules were firmly followed or adhered to. It does raise questions over the intent behind this decision and the future direction of this role. The lack of transparency is alarming, and our call for this board is to hold to the standards of transparency, fairness, and professionalism that your duties demand. Voters, candidates, county offices, and the people of Georgia do deserve a hiring process they can trust and know that upholding the nonpartisan commitment to free and fair elections, which is a standard this board has failed to meet in the past with serious consequences. Our state does deserve better, and your role as public officials demand it.
Thank you, Ms. Bell. That concludes our meeting for today. We will reconvene at 9 a.m. The chair would entertain a motion for recess at this time.
So moved.
We have motion for recess. Is there a second?
Second.
We have motion and a second. All those in favor signify by saying aye.
Aye.
Hearing no opposition, so moved. This board is now in recess until 9 a.m. in the morning. Thank you all. And please drive safely home.